time is 12:23 p.m. The Committee on Criminal Jurisprudence will come to order. The clerk will call the roll.
Chair Moody,
Present.
Vice Chair Cook,
Present.
Representative Bojani,
Present.
Representative Bowers, Representative Darby, Representative Harrison,
Here.
Representative Leach, Representative Christina Morales,
Here.
Representative Schatzline.
Here, thank you. Quorum is present. As a reminder, anyone present wishing to testify on any of the measures that we're hearing today, please register at the kiosk located in the hallway behind us. If you're in need of assistance, please let us know and we will help you out. Let the record reflect that Representative Bowers has joined us. We do have, as we've been doing all session, a 3-minute time limit for your remarks and testimony. We have a timer up here that you can keep an eye on. It has a very obnoxiously loud beep that I won't use unless people start abusing the timer. Thank you. Okay. So keep an eye on it. Green, yellow, red. I think it's self-explanatory. That's outside of questions that the members want to ask you. So just so you know, those are your prepared remarks. Want to keep in there. For planning purposes, we're going to hear bills up front and then vote on some pending matters at the back end of the hearing. So for your all staff, that'll be at the end of everything as we get to that point. I do want to, let's see, before we start, Chair refers the following bills to the Subcommittee on Asset Forfeiture. House Bill 1711, House Bill 1714, House Bill 1874, House Bill 2992, House Bill 3758. Chair refers the following bills to the Subcommittee on Criminal Procedure. House Bill 1136, House Bill 1178, House Bill 1383, House Bill 1908, House Bill 1909, House Bill 1921, House Bill 2380, House Bill 3005, House Bill 3686, House Bill 3688, House Bill 4037, House Bill 4671, House Bill 4776, House Bill 5007, House Bill 5041, and House Bill 5159. I saw Mr. Bojani's eyes get very wide. For planning purposes of everybody else, the full committee is planning on meeting next week, and on the 18th, we'll have the subcommittees meet. So if members have stuff there, that's the week that we'll be hearing it that way. So y'all can plan accordingly. And with all of that business behind us, the chair lays out House Bill 948 by Chairman Dutton and recognizes Chairman Dutton to explain the measure.
Thank you, Mr. Chairman and members. House Bill 948 is a bill that I filed during the last session also. What happened in this case was, in almost every case, when a person is released on parole from one of the Texas prisons, there are conditions they have to meet to remain on parole. Well, sometimes there's an allegation that they violated one of those conditions. When that happens, they can be taken back to jail, given a hearing. But in the meantime, whenever that happens that they violated a condition of their parole that's alleged to be against the law, for example, in the case that I represented a gentleman on, it was alleged that he had a pistol in his hand. His neighbor 3 houses down said he saw him outside with a pistol. And he said he didn't have a pistol. His wife said he didn't have a pistol. The daughter said he didn't have a pistol, but he was arrested anyway for felon in possession of a weapon. Well, the judge gave him a bail on felon in possession of a weapon, but he had a no bond on the alleged violation of the parole condition. So think about that. The underlying offense is the one he got the bail on, the bond on, but then for the alleged violation of a parole condition, he got a no bond on. So what House Bill 948 did is just says that if the judge allows you a bond on the underlying condition in that situation, that will be assumed for all purposes, so that it'll be a bond for the alleged parole condition violation as well. And that's all it does. And I'll be happy to answer any questions.
Thank you, Chairman.
Speaker member.
Appreciate it. Any questions for Chairman Dutton? No? All right, we do have a witness registered. Chair calls Sheriff Brian Hawthorne. I have you registered as Brian Hawthorne, testifying on behalf of yourself and the Sheriff's Association of Texas in support of the bill. Is that correct?
That is correct, Chairman.
Go ahead and begin your testimony. Thank you.
So Chairman Dutton laid it out almost perfect. And in fact, my district attorney is sitting here in the room with us, and we spent hours trying to clean up a very similar scenario to what he just described. But it was actually where one of our deputies had made an arrest. When you got deep into the law, the arrest was probably not good, so the Justice of the Peace was going to PR him out. But by that time, TDCJ, or the parole board, had already put a hold on him. So we could get him out of jail, and then on Monday, the DA's office could handle the problem, but we couldn't let him go because they'd already put a technical violation hold on him. So he sat in jail for 72 hours when he really shouldn't have been sitting in jail for 72 hours. The Sheriff's Association of Texas has always supported trying to limit these technical violations because quite often we see them being used as punishment versus the actual reason for why they need to be in there. So from an SAT's perspective, we support Chairman Dutton's bill, and we do think it's a very good bill.
All right. Thank you, Sheriff. Do you
Thank
have
you,
questions
Chairman.
for the Sheriff? Mr. Bojani, did you? Go ahead.
I just want to preface this question. I am an attorney, but I don't practice criminal law, so please bear with me here. I'm trying to understand why are we releasing an individual who has been out on bond and has committed, it says, an offense, a new offense, during the release or after the release. So I'm really not understanding this bill.
So I think sometimes what we find is that new offense, they shouldn't be found guilty based upon until they've gone through the process in the system, because obviously you're innocent till proven guilty. And if he's making bond on that new offense, he's not guilty of it. He's just been arrested for that new offense, but he's being held on a technical violation, and he remains in jail, remains in custody, and most of our jails are full on a technical violation when, in fact, he bonded out and has made bail on what he was arrested for.
So this takes away discretion from the judge or magistrate to say that you have to release them if these criteria are met.
So,
right?
No, so what it does, that the magistrate doesn't have any discretion on that technical violation. That's part of the problem. If we wanted to just give the magistrate that discretion, that would be fine. But the bottom line is there is no discretion on the magistrate on that technical violation, only on the bond. So they'll grant them bond, and they'll let them out. That bond will be based upon the type of crime it is. But even after they've made bond, they can't get out of jail until that technical violation is handled. And that could sometimes take weeks. If you're lucky, you can get it done in about 10 days. So from a sheriff's association, we think this is a very good bill.
And let's say for the second offense, if it is really an aggravated assault or much higher felony, we're still saying that the magistrate should release.
No, that'll be up to the magistrate on how he wants to set bond on that second arrest or that second charge. So each charge that he gets arrested for, he's going to have bond or bail established on those charges. It's the technical violation that the parole board is placing on him that is holding him in our facilities when in fact they had the ability to be bonded out on the crime that they have been charged with.
Okay, got it.
So they're two different issues, and what he's trying to do is if you can make bond on one, you ought to be able to get out on the technical violation also, and we agree, based upon a lot of factors from a sheriff's association.
Thank you.
All right.
All right, thank you. Do you have any other questions for the Sheriff? No? Thank you, Sheriff. Appreciate you being here.
No, thank you, Chairman.
I do want to say we have a witness from TDCJ available to testify if any member would like to ask questions of that resource witness. Sure, let me do that. Let me switch. Where do we have? Oh, she's not registered as a resource. Actually, let's just do this. If you could offline connect, we have someone here and they'll let you know that information. I apologize, I thought they were already on here. Anybody else wishing to testify on, for, or against House Bill 948 at this time? No, it's okay. Chair sees none. Recognize Chairman Dutton to close on the measure.
Let me see if I can eliminate the confusion. This is not a person committing a second offense. What happens is the person has committed an offense for which they've been found guilty, and they've gone to prison. But now they've served enough time in prison that they get out on parole. So they're out walking around, they're on parole, and there's an allegation that they violated a condition of that parole. And so as a consequence, what TDCJ does is issues what they call a blue warrant for that person. That blue warrant is a no bond situation, but the offense that they are alleged to have committed that caused them to be arrested in the first place, the judge says, well, I'm going to give him a bond on that. So he gives him a bond on that, but there's a hold on him because there was an allegation that he violated a condition of his parole. I hope that
Yeah.
kind of understands, because it's not like you're letting somebody out who hasn't been to court, hasn't committed an offense, and now he's out while he's on bond, he commits another offense. That's not the case here. This is a case where a person has been to prison already, and he's only now alleged to have violated a parole condition, which also could be a violation of the law, but it's an allegation at that point. And so if the judge who's making the decision about bail says, no, I'm going to give you bail, I'm going to give you bail on the underlying offense, but I can't give you bail on the alleged parole violation. And that's what this bill is saying, that, wait a minute, if the judge grants a bail on the underlying condition, that bail is also sufficient for the parole allegation violation. And that's all it is. And so I thank you for your consideration. I started smiling because this is one of the first times in my career that me and the sheriff's association been on the same side. So anyway, I had to look at my bill again. But anyway, I appreciate the testimony. Thank you.
All right, if there's no objection, the bill will be left pending. Is there any objection? Chair hears none. House Bill 948 is left pending at this time. Chair lays out House Bill 2696 by Representative Howard and recognizes Representative Howard to explain the measure.
Thank you, Chair Moody and Vice Chair Cook and members of the committee. The Sexual Assault Survivors Task Force, also referred to as SASTF, was established by this legislature in 2019 with the intent to create a survivor-centered, trauma-informed, collaborative, and coordinated response to sexual violence experienced by adults and children in Texas. The group is led by a steering committee that includes the Children's Advocacy Centers of Texas, the Texas Association Against Sexual Assault, and the Office of the Governor. Other members of the SASTF include a long list of groups. Just to refer you to a few, though: the Office of the Attorney General, the Texas Commission on Law Enforcement, the Texas Forensic Science Commission, the Texas Department of Public Safety, Texas District and County Attorneys Associations, and then there's also a wide variety of other health-related groups that are a part of this, just a wide range of folks. And I have to say, I'm really proud of the legislature for doing this, because what this has done is it's brought all of these groups together who, in some form or fashion, deal with survivors of sexual assault. And rather than functioning in silos, they're actually coming together, and they have been for the past several years now, and working together to communicate with one another so that the response to sexual assault survivors is one that's informed along the whole way and learning what we can do to have best practices in place. And it's just been phenomenal. Over the past 4 years, they've worked with stakeholders across the state, provided hundreds of recommendations to state agencies, local law enforcement groups, community stakeholders, and to the legislature. And last session, we passed all 11 of the policy recommendations that were submitted to us by the SASTIF. These recommendations improved access to our safe, ready facilities, ensured all survivors have access to a forensic exam, and improved access to survivor-centered services in rural areas. 2696, HB 2696 would amend, and this is a recommendation from this year. They have 12 recommendations they've brought us this legislative session. HB 2696 would amend the definition of consent within the sexual assault statute to provide clear protections for victims in circumstances that are not explicitly covered by Texas law. And just as Representative Bojani just did, I am not a lawyer, so I am going to be talking about this from my perspective as a layperson. We do have resource witnesses here that can actually get into the law with you more, though, if I don't have the ability to answer your questions. Current law does not provide a clear definition of consent with respect to sexual violence. It does not specify how consent is to be communicated or understood. This has contributed to low prosecution rates for sexual assault cases, as this vague statutory language allows perpetrators to avoid prosecution. To put it in perspective how current law has created a barrier to justice for survivors, the latest FBI records estimate that in 2020, Texas had an estimated total 13,509 rape offenses, the highest in the nation. And that's just the number of reported sexual assaults. According to research done by the Institute of Domestic Violence and Sexual Assault, only 9.2% of victims actually reported their experience to law enforcement. And of those, about 3% actually proceed to a full investigation and trial. This is why this legislation and their recommendation is paramount. HB 2696 would clarify that consent must be expressed or apparent and can also be withdrawn even once the act has been initiated. Additionally, this bill states that sexual assault is without consent if the perpetrator knows or should reasonably know the victim is intoxicated or impaired by any substance and cannot give consent. Current law requires the actor to intentionally impair the victim by administering any substance. This narrow definition is not clear and cannot be applied in situations in which a person is intoxicated of their own volition and is assaulted by another person. These clarifications in HB 2696 will help prosecutors hold these criminals accountable for their crime and will help to transform Texas's response to sexual violence. We can and we must do more to improve the justice system and ensure that survivors actually have confidence in our system. This bill is the product of prosecutors who work in this space and also working with the governor's office. Updating the consent statute could both encourage more to pursue justice through the law, as well as contribute to a culture change in which every survivor in Texas feels supported and believed throughout the process. This session, we have the opportunity to once again move Texas toward a future in which all survivors of sexual violence have access to the services, programs, and resources necessary to heal. So I'll be happy to answer any questions, Chair Moody, and reserve the right to close.
Thank you. Members, any questions? I just want to thank you for all of your work on this. These are issues that we've grappled with for some time, but I think one of the solutions you propose here in talking about fixing our intoxication portion of the statute is so it is absolutely mind-boggling to me that you can stumble upon someone who has gotten themselves intoxicated and not have not have the same criminal liability as of someone who is involved in that intoxication. To me, the situations are the same in the ultimate conduct. And so the fact that you were spending the time with that person doing that to them or not, it seems to be, always seemed to me to be a problem in the statute. So I appreciate you digging into this. This is a matter that's been taken up multiple times and can be very complex. So thank you.
Thank you, Chairman. And I understand this is a culmination of many legislators' efforts to get here. And I am extremely grateful to the SASTF and working with the governor's office to get some language that can be agreed upon here. So appreciate your favorable consideration as we listen to the witnesses.
Thank you. We do have some witnesses here.
Thank you.
Chair calls Lavinia Bertha Masters. I have you registered as Lavinia Bertha Masters, testifying on behalf of yourself and Hope Saves.
Yes.
In support of the legislation. Is that correct?
Yes, sir, it is.
Go ahead and begin your testimony.
I am Lavinia Masters, and I am a survivor of sexual assault. I'm an advocate. I also work with TASA on the task force, all those great things. But most importantly, I am a survivor, and I support House Bill 2696 and us doing the verbiage of consent. I'm infamously known for the Lavinia Masters Act and my rape at 13, but this sexual assault happened in college freshman year by a young man who was esteemed highly by the school on the dean's list, a senior, all these great things. We talked, and I was under 21, but I had a wine cooler, and he put something in my drink. And at that point, the assault was not reported because I felt I took a blame for it. I thought it was my fault, but it wasn't my fault of the things that happened to me. And when you learn consent, when you see how consent is and how we look at it, we figure, okay, well, she had some part of it, or she could have said no, she could have said stop, but I told him in the beginning this is not what we were going to do. I was drugged and taken back to his dorm room. Consent to me is mutual respect for one another. You respect me, you see me as a person, you see me as an individual, and vice versa. It's not you take advantage or you're an opportunist because you see, she's under the influence, or she should have known better. She's not even a legal age to do so. That still doesn't give that perpetrator a right to take advantage of me as an innocent victim. So until we get to that space where we can understand what mutual respect is for one another, I know we have many definitions of consent, and it shouldn't be any separate definitions of or how the law sees consent. Consent is consent. I raise my son, no means no. I don't go into yes mean yes. No means no. My grandson, no means no. Give them their space. If they can't communicate, if we're under the influence, if they have drugs, I don't care what it is. No means no. And this is how we should all look at consent. We should be definitive about it when we say that we're going to give consent to someone and have mutual respect for one another as individuals. Thank you.
Thank you very much, and I certainly appreciate all of your advocacy and work in this space.
Thank you.
Members, do we have any questions? No?
Thank you.
Thank you. Chair calls Lindsay Richards. I have you registered as Lindsay Richards, testifying on behalf of yourself and the Williamson County District Attorney's Office in favor of the legislation. Is that correct?
That's correct.
Okay, go ahead and begin your testimony.
Good afternoon, Chairman Moody and members. I am Lindsay Richards, and I am here representing the Williamson County District Attorney's Office and in support of House Bill 2696. A young female meets a man on a dating app. They go out, they have a couple drinks. He's nice, he's charming. She likes him, she feels safe with him, and so she agrees to go back to his apartment close by for a nightcap. She gets there and makes it clear that she does not want to engage in sexual activity. She leaves her purse near the door with her phone in it. They sit on the couch, and he gets on top of her, making it difficult for her to move her arms, takes her clothes off, and begins to have sex with her. She does not know what he is capable of doing. She does not know where she is, how to get out, doesn't have access to her phone, so she lays there and lets it happen. She begins to cry as he continues. We can all agree in that situation that a sexual assault occurred. We can all agree that she was clearly not consenting as she lays there crying. But under the rigid language of the statute, the current statute, that is not a case that we would be able to prosecute. I am currently serving as the adult sexual assault prosecutor in Williamson County. I am also a member of the Sexual Assault Survivors Task Force, the group responsible for these consent changes. I handle all of the adult sexual assaults from intake, working with law enforcement, all the way through trial. And I've prosecuted hundreds of these sexual assault cases, and I've also tried dozens of them. The most pervasive issue that all prosecutors face when dealing with sexual assaults is that it doesn't consider the nuances of this type of case. There are numerous cases where we know a rape occurred, but because of the statute, we can't move forward because the facts that we're seeing don't actually fit into the rigid language. As a prosecutor, I've had to sit across from countless survivors and tell them, we know this happened, we know he's guilty, but there's nothing that we can do for you. And I'm asking you, by making these changes, by supporting this bill, is basically just give us a ring to fight in. I'm asking that as the state of Texas is having conversations all across the state about why are these cases not being prosecuted the way that we think they should be, and the reason is because of the language of the statute. I'm asking you, by supporting this bill, to be a part of that solution, and so as we move forward, you can be a part of the change in the way we prosecute these cases. The language that's added is the intoxication language, the should have known language, which creates the standard of a reasonable person and how a reasonable person would appraise consent. A reasonable person standard is used in almost all of the other criminal offenses. So why are we not using it here? It also clarifies that consent can be express or apparent and can be withdrawn at any time, which is a fact scenario we often see in these cases. It allows prosecutors to have to stop having to fit imperfect people into a perfect box for us to prove that a rape occurred. Thank you for your consideration, and I'm free for any questions.
Lindsay, thank you very much. Members, do we have questions? I just want to say I appreciate the work that you do. Having had the opportunity to prosecute a couple of these cases, they're incredibly complex. They're very difficult. Statute aside, the fact patterns in some of these issues, I mean, they're very, very challenging. And so doing that work day in and day out is certainly got to be difficult, but I appreciate you doing it.
Thank you.
Thank you. Chair calls Tiffany Larson. I have you registered as Tiffany Larson, here testifying on behalf of yourself and the Harris County District Attorney's Office in favor of the legislation. Is that correct?
Yes, sir, that's correct.
Go ahead and...
Good afternoon. My name is Tiffany Larson. I am the chief of our Adult Sex Crimes Division in Harris County. I have been a prosecutor in Harris County for over a decade now, and I'm here to support House Bill 2696. In the time that I have prosecuted sexual offenders, I have seen just about every fact pattern that a terrible mind can conjure up. And what I can tell you is that though we have a statute that is long, it just doesn't cover all of the bases. We've added to it many times over the past several sessions, and we're tackling more predatory behavior than ever before. But what we're failing to do is encompass the essence of what a sexual assault is. It's a taking. The more I work on these cases, the more I realize that sexual assault is just one person taking something that the other person doesn't want to give. In essence, it's a theft. When it comes to theft in Texas, we require effective consent, which is the presence of a yes, not the absence of a no. If you think about it, Chairman Moody, if I walk up and I take your cell phone, it would not be a defense to me that, well, he didn't say no, and it seemed like he was okay with it. Certainly, if you're intoxicated at a bar, Representative Darby, and I take $50 out of your wallet because you're too intoxicated to notice, everyone would agree that that is a theft. It would not be a defense. But that is what we need to change here in Texas. Sexual assault should be no different, and House Bill 2696 addresses this directly by adding the words reasonably should know, and by clarifying that consent has the same definition that it carries throughout the rest of the penal code, which is expressed or apparent consent. We will be able to appropriately hold offenders accountable and prevent them from taking advantage of this obvious loophole in our penal code. Victims of sexual assault really should never have to hear me tell them, I cannot fit what happened to you into our statute. And those are phrases and words we are using all too often throughout the jurisdictions across Texas. So let's fix the problem. Let's hold sexual predators accountable by shifting the focus to their behavior. Did they actually have consent? Instead of focusing on whether or not the victim raised any objection. Consent is not a given, whether it be money or sex. And so we have to make that clear in Texas. And so I respectfully request and enthusiastically request that you support House Bill 2696. I'm available for any questions.
Thank you, Tiffany. I appreciate it. Members, do we have questions? And I certainly just want to, offer the same gratitude for doing this work. I appreciate that.
Absolutely. Thank you all for your time.
Chair calls Justin Wood. Have you registered as Justin Wood, here representing the Children's Advocacy Centers of Texas, neutral on the bill?
Good afternoon, Chair.
Is that all correct?
And members, that is correct.
Okay, great.
And I'll just be brief. Myself and my colleague Liz Boyce with TASA are both signed up as resource witnesses. I'm here testifying on the bill. I represent you today. I'm here before you today representing as a member, a steering committee member of the Sexual Assault Survivors Task Force. As I said, I work very closely with my colleague Liz Boyce at TASA. We help guide some of the policy recommendations that are brought to you. In my role with the task force, I also lead the prosecutor working group that Lindsay and Tiffany are both a part of and mentioned. And I would just say that this is not a new conversation in Texas, as you know. There's been many of your colleagues that have been fighting this issue as well. I was a career prosecutor in a former life for about 17 years and have worked these cases, staffed these cases, tried these cases, and we all know the difficulties that the current consent statute presents, as they have very well articulated. We've continued to add to ways that a person cannot consent, and while very well intentioned, that is not an effective way to really address some of the prevailing issues in these sexual assault cases. So the consent recommendation that you have before you, as Representative Howard laid out, is the work of a lot of dedicated prosecutors that just like you've heard from today in Lindsay and Tiffany, and really diving in and saying, how can we bring a statute to you that will, or suggestions to you that will give them the tools to effectively prosecute these cases? And they said it as well as I can. And we're here as a resource if you have any questions.
Members, question for Justin? No, thank you so much.
Thanks.
And I know you said Liz was here in the same capacity. Let me go call you up. Chair calls Liz Boyce. I do have you registered, testifying neutral on the bill and representing Texas Association Against Sexual Assault. Is that all correct?
Yes, sir.
Okay,
It
go
is.
ahead.
Good afternoon, Chairman Moody and committee members. I am Liz Boyce, General Counsel at the Texas Association Against Sexual Assault, also known as TASA. TASA is the membership organization for Texas's rape crisis centers, sexual assault advocates, and allied professionals, and we provide training, technical assistance, and advocacy for sexual assault survivors in the aim to eliminate sexual violence in Texas. First, I'd like to thank Representative Howard for carrying this very important legislation for always prioritizing sexual assault survivors. And thank you to this committee for hearing the bill today. TASA is privileged to be a named statutory member of the Governor's Sexual Assault Survivors Task Force, and since its inception in January of 2020, we have worked alongside Children's Advocacy Centers of Texas and the Office of the Governor on the task force steering team. Our collective work has produced dozens of policy recommendations to improve our criminal justice system's response to sexual violence and to create more trauma-informed practices for investigation and prosecution. HB 2696 is one of our many policy recommendations for the 88th legislative session, and the witnesses before me have aptly demonstrated its potential to improve our prosecution rates and hold sexual offenders accountable. At TASA, we stand for survivors like Lavinia Masters, whom you heard from previously, and we support their choices, whether they report their crime or whether they choose to stay silent. But when they make the undeniably brave choice to disclose what happened to them, we believe that they deserve comprehensive laws to support them and help them find justice. We believe this law takes a positive step forward in that direction and furthers the governor's goal to eliminate rape in the state of Texas. Thank you for your consideration of my testimony, and I'd be happy to answer any questions you might have.
Liz, thank you so much. Members, do we have questions? No. Thank you for all of your work on this. Is there anyone else wishing to testify on for or against House Bill 2696 at this time? The chair sees none and recognizes Representative Howard to close on the measure.
Thank you, Mr. Chair. Members, I am so proud of the SASTF. I hope you are as well. This has been incredible, and we as a state are leading the nation in our response here. It is just an incredible amount of work that these people have been doing, and I am just blown away every time I hear them talk. Talking here today, as we just heard, about the undeniably brave choice that some people make that have been assaulted when they decide to report it. That very small number who actually decide to report it, it is a huge step to do that. And we need to give the prosecutors the tools that they need to ensure that they can follow through with this prosecution. Answering the question, why are cases not being prosecuted? And as they said, because of the language in the statute. Give us a ring to fight in. The reasonable person standard, you should have known. Had a list, keep adding to this list, but that's not encompassing everything. And come to determine that this is actually a theft. It needs a presence of a yes and not just an absence of a no. To me, this is extremely rational and reasonable as a layperson, and I keep hearing about this and it keeps being explained to me. I hope it means the same kind of rational, reasonable way that we can move forward to you. I can try to answer any other questions. I think you heard very well from those that testified here today. But I would very much appreciate your favorable consideration of this. And if there's no other questions, I close.
Thank you, Representative Howard. Members, do we have questions? Yes, Representative Morales.
I just want to commend you and thank you for your for bringing this bill forward. I know that you're absolutely right when you say that the bravery of people who come forward, you know, to let folks know what happened. It is so, so hard. And I can assure you there's many people in this room who have friends who have been in that situation. And many of them chose not to speak out. Right. So, so anything that we can do to support those folks would be just amazing. And so I fully support this. Thank you so much. Thank you for doing it.
Thank you.
And just to reiterate, not that you mentioned it in your opening, every recommendation last session was passed into law.
That's correct. And
that is why this group of experts working together on this issue, which is challenging in so many different ways. The legal one only being one of them. Mm-hmm. It's important to have that institutional knowledge continue to work, and this is their next round of recommendations. So I appreciate you working on it. I look forward to moving this to the House floor.
Thank you all so much. I close. Sorry.
Chairman.
Oh, was there? I'm sorry, Representative Bowers.
Thank you. Thank you, Mr. Chairman, and thank you, Representative Howard, for bringing this legislation before us, and to all of the witnesses that testified so strongly. Very compelling testimony. And I want to ask you just a quick and simple question. Is this in the clerk's office?
I think so. If not, it will be immediately.
Thank you. I would like to sign on, and yes, I would like to sign on, and I just appreciate your bravery and courage for being the vessel to bring this to us.
A vessel is exactly what I am. The people that are brave are the survivors like Lavinia who keep coming forward, and then these great people who are working in the field. So
thank you.
Thank you.
Thank you.
Close.
Members, if there's no objection, House Bill 2696 will be left pending. There's objection, the chair hears none. House Bill 2696 is left pending at this time. Chair lays out House Bill 1993 and recognizes Chairman Harris to explain the measure.
Thank you, Mr. Chairman and members. I appreciate the opportunity to lay out House Bill 1993 before you today. Currently in Texas and throughout the U.S., fuel stations are being targeted by fuel thieves who illegally acquire diesel fuel by using stolen credit and debit card numbers, breaking into fuel dispensers to manipulate the internal fuel pump pulser devices, and by siphoning off diesel fuel from underground fuel tanks at truck stops and convenience stores. One of the primary methods used by the Comptroller's Criminal Investigation Division to track fuel thieves is by utilizing mobile tracking devices. Mobile tracking devices are a tool used by law enforcement to track suspects' vehicles. These devices alert law enforcement to the location of a vehicle without alerting suspects. The Comptroller of Public Accounts Criminal Investigation Division, the state's subject matter expert in crimes related to motor fuels theft and tax evasion, regularly uses mobile tracking devices when investigating these crimes. Under current law, only authorized peace officers may apply to a district court for a warrant to install and use mobile tracking devices. And comptroller peace officers are not authorized peace officers for this purpose. Despite being able to obtain and execute evidentiary search warrants on businesses, residences, vehicles, cell phones, and other portable electronic devices on active felony investigations, peace officers in CID must request assistance from other local and state peace officers to obtain a warrant for a mobile tracking device. This bill amends the Code of Criminal Procedure to add peace officers commissioned by the comptroller to the list of individuals who can apply to a district court for the installation and use of a mobile tracking device. Thank you, members. I reserve the right to close and will defer to witnesses to speak for the bill if there are any.
I don't have anybody registered, just real quick. I just want to make sure I get it. They can pretty much do everything up and down this chain of this investigation, except for this piece, which is critical to their investigation.
That's correct.
So this
Excuse me.
Okay, so this is just making sure they wholly house the authority to run these investigations where they're doing anyway, and kind of keeps them from having to take that additional step of essentially getting someone else to bless this.
Exactly.
process.
Yes, sir.
Okay, makes sense to me. Yes, Mr. Bojani.
Thank you, Chairman. Hey, Chairman. Just wanted to quickly ask, since I've been in the gas station industry for the last 24 years, this is probably what you're thinking about is the wholesale distributor that
Probably most likely it's going to be the wholesale distributor sites that are the most common violations or thefts that occur. Yes, sir.
I've had a few times where the wholesale distributor truck or the load comes in of fuel. They're like, I'm going to charge you $1 per gallon for the 500 gallons I have, which that person must have shorted it to another gas station. And then I said, no, I'm not going to buy stolen stuff. So, I think that probably happens on the wholesale level. And so there are comptrollers that are looking at that and trying to place devices on their trucks.
Correct.
To see if they go deliver here. They're supposed to go deliver here, but then they go make another stop right after it. They must be shorting it into one customer to give it to another customer.
Yeah, there's all sorts of different clever mechanisms that they use to steal the fuel.
Okay, makes sense. Thank you.
All right, just hang out right there. Is there anyone wishing to testify on, for, or against House Bill 1993 at this time? The chair sees none. We recognize Chairman Harris to close on the measure.
Thank you, Mr. Chairman. Members, I close and would appreciate favorable recommendation of this bill.
All right. Thank you, sir. Appreciate it. If there's no objection, House Bill 1993 will be left pending at this time. Is there any objection? Chair is none, and House Bill 1993 is left pending. Which committee members do we have with the bill? Do we have any with? Right here. We do. You want to do 909? Let me see if I can, in the interest of keeping things. Is his bill here? I guess I'm not here, but I'll text him. I kept reading reports about 500 bills being heard this week or something like that. I guess that's where everybody is. I think half of them are in JCJ. We got a couple members on their way right now. Just be patient with us. Thank you. You win, Mr. Patterson. You're here. Chair lays out House Bill 844 and recognizes Mr. Patterson to explain the bill.
Thank you, Mr. Chairman and committee. Thank you all so much for allowing me to lay out House Bill 844, adding simply 2 words to the penal code. That's it. But no matter how small the bill is, we're going to provide a lot of good help to a lot of people that need it. This bill helps protect and aid vulnerable individuals who have suffered from the physical and emotional hardships of human trafficking. Currently, Section 20A.01 of the Penal Code requires third-party identification for an individual to receive the services necessary to overcome their traumatic experiences. HB 844 alters this definition to include 2 terms, solicit and patronize, therefore removing the need for a victim to identify their trafficker. This new definition would remove third-party requirement for victims of human trafficking. Children cannot consent to any sexual act. Therefore, a child would not have to identify a trafficker in order for the sexual act to be considered non-consensual. This legislation will protect victims due to any fear that may occur if they were to identify the involved third party, and would not change any protections currently in place for children. This is an issue that is being addressed across the country. For example, Florida has added the terms purchasing, patronizing, and solicit. Tennessee has added purchases to their definitions for trafficking. Furthermore, the U.S. Federal Code includes solicit and patronize as well as what we're trying to do in this bill. That's what 844 mirrors. I look forward to hearing all the testimony and hope light can be shed on why this legislation is so desperately needed. But I'd be happy to answer any questions you may have.
Thank you, Representative. Members, do we have questions for Representative Patterson? We do have a couple of witnesses registered, so let's
Yes, sir.
Take testimony and we'll bring
Reserve
you
my
back up. Yes, sir.
Thank you.
Mm-hmm. Chair calls Jason, is it Jason Sabo? Sabo. There's a few different ways I could have gone there. Sabo. I have you registered as Jason Sabo, representing children at risk, testifying in favor of the bill. Is that correct?
That is correct.
Okay,
and actually, you pronounced it as they did at Ellis Island, so you got it right. Children at Risk supports this bill. My name is Jason Sabo. I am here thanking Representative Patterson for filing this legislation, thanking the chair and the committee for hearing it. Current penal code with regards to human trafficking is related to transportation, enticement, recruiting, harboring, providing, or otherwise obtaining another person by any means. It does not include the words solicit and patronize, which in many ways are the words of business, recognizing that this is a commercial industrial activity. And the changes being proposed by Representative Patterson clearly recognize that this is a commercial exchange. What we also like about this bill, not only is it kind of highlighting the fact that if you're going to combat human trafficking, you have to look at the demand side of it, the purchasing side of it, the soliciting side of it, the patronizing side of it. It also, to the representative's point, highlights and expands opportunities for services to women and victims of human trafficking who might have been solicited and patronized, as we can see. So in many ways, this bill does feed 2 birds with 1 seed. It fights the demand for human trafficking as well as increasing and expanding services to the victims of trafficking. And we thank the representative for doing this, and we're happy to answer any questions. Thank you for your time.
Jason, thank you very much. Members, do we have questions? No? Thank you.
Thank you.
Chair calls Stacy Dela Cruz. I have you registered as Stacy Dela Cruz, representing yourself and Shepherd's Watch Foundation in support of House Bill 844. Is that correct?
That's correct.
All right, go ahead and begin your testimony.
Well, thank you for having me here today. I was going to say this morning, but Looks like it's in the afternoon. And my name is Stacy Dela Cruz. I work for Shepherd's Watch Foundation, which is a nonprofit organization that specifically works with sex trafficking victims. We do a lot of boots on the ground investigative work, and we do advocacy as well as referrals to our other NGOs as well as the law enforcement at all different levels, specifically for this population, whether it's adult or children. I am a founding member of Northeast Texas Alliance Against Trafficking, a member of the North Texas Coalition Against Human Trafficking, and a past member of the Attorney General's Task Force Against Trafficking. So I'm kind of in the middle of the muck. Be really honest, I'm not as eloquent as the rest of the people who have been witnesses, but I can tell you from firsthand experience and from my experience over the last 8 years what it's like when you're meeting with a victim and what it's like for them when they finally get out and somebody says, but you have to tell who did this to you. As mentioned by earlier witnesses and the other House bills, they mentioned that there's rarely any outcry. What was it, 9.2% of those who do speak out. It's very terrifying for them to speak out. Now imagine you're finally out and you have to identify your perpetrator. I have been with people who are children who finally got out, ID'd their perpetrator, the investigation continued, and harassment occurred. This is a child who's being harassed, and by the end of the investigation, she was too afraid to appear in court. The guy is on the street. He got 10 days in jail, $1,000 fine, and he knows where she lives. And forever, she'll be looking over her shoulder. Current penal code states that they must ID this person. If we force children or adults or anybody to ID, I'm sorry, I'm being really passionate about it. Sorry, forget the notes. If we force them to ID these people who have hurt them and who have threatened them and who they've witnessed beating, raping, killing, torturing people, we're re-traumatizing them. And we can't do that. Texas is a better state than that, and we have to take care of our children. We have to take care of our victims, and I know we will. We just need to change the language. It's been a popular statement today. Let me see what else I've got. Pretty much covered all that. Yep. Just so you know, for those who are not aware, sex trafficking is the #2 business in the world. Human trafficking, rather, is the #2 business in the world next to drug trafficking. It is a $99 billion business with a B, just for sex trafficking alone. The U.S. is 50% of that. That should be terrifying. And Texas is #2. So I'm just going to implore you to support House Bill 844.
That other one may be good too, but this is the one we have in front of us.
Yeah, sorry about that, 844.
That's okay.
And let's help these people move on with their lives so they can have a whole life again.
Well, I appreciate it. And I know there's a number of bills and some other things that are being done in this arena. I just want to make clear for the record, testifying in favor of House Bill 844 today, correct? All right. Thank you very much. Members, do we have any questions?
Any questions? Thank you for your time.
Thank you.
I appreciate you.
Is there anyone else wishing to testify on for or against House Bill 844 at this time? Hold on. Can you come up here real quick? No, come here real quick.
Oh, sure.
Chair calls Lindsay Speed. And I have you registered as Lindsay Speed, testifying on behalf of yourself in Traffic 911 in favor of the legislation. Is that correct?
That is correct, yes.
Okay, go ahead and begin your testimony.
Sure. My name is Lindsay Speed, and I am the executive director at Traffic 911. We are a nonprofit based out of North Texas, and I am for passing House Bill 844. Since 2009, Traffic 911 has had the sole mission of freeing youth from sex trafficking here in Texas. So for the past 14 years, we've been serving child sex trafficking victims, so that's why I'm super passionate about this specific bill. Our team of full-time professional advocates are first responders to child sex trafficking victims who get recovered and identified across North Texas. And so when they do, we get to pair them with a fully trained advocate, and we serve around 300 child sex trafficking victims a year. So I've had the privilege of just walking alongside a lot of survivors over the years who are survivors of sex trafficking. And one of the big barriers, to be honest, for most of the sort of survivors that we serve is that they don't always feel comfortable either identifying a trafficker or identifying a third party as it states in this bill. And so it can be a really big barrier and often take years. I know someone who's more in their 50s now, and this victimization happened to them when they were a teenager, and they're just now getting to kind of coming to terms with the fact that they were trafficked. And so because of this barrier and other barriers the child victims face, I really urge you guys to pass House Bill 844, which really is a best practice, not only on our federal code, but in several states across the nation. And so we really do owe it to our kids to not require them to identify a third-party trafficker in order to receive really needed services for being a victim of child sex trafficking. So thank you.
All right, members, do we have questions? No, thank you, Lindsay. I appreciate your time.
Thanks.
Is there anyone else wishing to testify on for or against House Bill 844 at this time? Chair sees none, recognizes Representative Patterson to close on the measure.
Thank you, Mr. Chairman. As you can tell, adding these two little words to the code can have a big effect. Certainly I want all these folks to be brought to justice that are committing this crime, but we shouldn't hold the victim responsible if they cannot, for whatever reason, identify the person doing this to them. And so I'm hopeful for your consideration, even if it means going to LNC. That would be great. So we'll see.
All right.
With that, I close.
Aren't you on calendars?
Yes, sir.
You can't shepherd it through there?
I might. I don't know. I know some people.
What? Oh, do you have a question? Yes,
Oh.
Representative Schatzline.
I just want to say I think this is an incredible bill. I work directly with victims in anti-human trafficking. This is one of the biggest issues we see is seeing these victims that might not be able to identify, but it's very clear that they need help. So thank you for carrying this. It's going to be good.
Thank you for what you do.
Yeah.
All right, members, any other questions? No? All right, thank you. If there's no objection, House Bill 844 will be left pending at this time. Is there any objection? Chair is none. House Bill 844 is left pending. Chair lays out House Bill 1506 by Chairman Meyer. Recognizes Chairman Meyer to explain the measure.
Very good. Thank you, Mr. Chairman. Committee, very simple bill. HB 1506 amends the Code of Criminal Procedure to extend the statute of limitations for the offense of abandoning or endangering a child from 5 years from the date of the commission of the offense to 10 years from the date of the commission of the offense. That is all this bill does. It is certainly needed to extend the time period, especially as it relates to a victim who is a child. Thank you, members. With that, I respectfully reserve my right to close.
Okay. Stay close. Members, do you have any questions for Chairman? No? Is there anyone wishing to testify on for or against House Bill 1506 at this time? Chair seeing none, recognizes Chairman Meyer to close on the measure.
Thank you, Mr. Chairman. Committee, I respectfully close.
Thank you, Chairman. If there's no objection, House Bill 1506 will be left pending at this time. Is there any objection? Chair is none. House Bill 1506 will be left pending. Okay, let's do this. We have 3 members. I don't have witnesses on one. I'm going to do that one real quick. Chair lays out House Bill 1731 and recognizes Representative Jones to explain the measure.
Good afternoon. Thank you, Mr. Chair and committee. I appreciate the opportunity to speak with you about House Bill 1731 today, which will ensure that students, full or part-time, charged with nonviolent misdemeanors are given personal bonds instead of having to pay cash bail. thus providing greater flexibility and opportunities for students to continue their educational opportunities. Number one is a targeted approach. This bill seeks accountability of students, full or part-time, who are charged with A, a nonviolent misdemeanor, B, who are under 26 years old, C, who have no previous convictions for domestic violence, and D, who have not been previously the subject of a protective order, to not be locked up while waiting for trial to the detriment of their studies, because pretrial detention has a significant negative impact on students. Two, it promotes the continuation of education by allowing accused students who are innocent until presumed guilty, enrolled in an institution of higher learning, to be released on personal bond. It therefore minimally interrupts a student's education. This will offer young students the opportunity to further their education, which can lead to better job opportunities, higher incomes, and improved quality of life for themselves and their families. Three, it ensures safety. Although the bill allows for the pretrial release of certain eligible college students, it also recognizes the importance of public safety. Consequently, magistrates may still require defendants to comply with other bond conditions to ensure society is protected and that they show up to court. For example, staying away from certain places or things, wearing an ankle monitor, all other kind of things that they may have to do to make sure that society is protected. Overall, this bill is a positive step towards addressing the special issues related to young students who are charged with crimes. By promoting education, protecting young adults, and ensuring public safety, the bill ensures a more just and equitable criminal justice system. It also helps for these young people to be able to learn from their mistakes and or fight to prove they're innocent without the financial burden they potentially can't afford as students. It also saves them from missing days of classes, which necessarily causes them to fail classes and lose money when they are least able to afford it. This bill is meant to seek justice while appreciating that youth is sometimes wasted on the young, but that most young people will eventually age out of dumb and youthful decisions. I respectfully rest and reserve my right to close.
Yes, ma'am. We have questions? We did actually have someone register. So go ahead and sit tight real quick. Chair calls J.R. Woolley. I have you registered as J.R. Woolley, testifying on behalf of yourself and the Justices of the Peace and Constables Association in opposition to the bill. Is that correct?
That is correct, Chair.
Okay, and begin your testimony.
I am Judge Woolley. I represent the Justice of Peace and Constables Association, and we are against this bill as it's currently written. It's a pretty well thought out bill, but there's a few little tweaks that we're already working with Representative Jones's office on to make it more amenable for us. So that's essentially it. Just some very minor tweaks that we're talking about.
And y'all are communicating?
Yes, sir.
Okay,
yes,
good. As long as everybody's working together, that works for me. Members, do we have questions? No? Thank you very much. The record reflect that Chairman Leach has joined us. The chair recognizes Ms. Jones to close on the measure.
I think this bill is the right thing to pass, and I respectfully request your favorable consideration for HB 1731. And with that, I close.
Yes, ma'am. Thank you very much. All right. If there's no objection, House Bill 1731 be left pending at this time. Is there any objection? Chair hears none. House Bill 1731 is left pending. Let's do this. We got three of y'all. Let me go in this order. I'm going to go with Victoria, then Cody, and then Janie. I see you over there. Are there any other members here besides that? Okay, let's do that real quick. Chair lays out House Bill 2019 and recognizes Chairwoman Niave Criado to explain the measure.
Thank you, Chairman Moody and Vice Chair Cook and members. Good to see you all, and very grateful for this opportunity to present this bill. And I want to give some background and context about this bill and why we're here. It's a very nuanced, specific bill. You're going to hear today from our Dallas County District Attorney's Office, who talked to us about the issue that they have seen, which gave us a need for this bill. But also I'm very excited because Lavinia Masters, who is the person who we named the Lavinia Masters Act in 2019 that we carried, was omnibus legislation. Many of you, all of you who were here supported that legislation. She's here. She's going to be telling her story and how this specific bill will help with respect to sexual assault. So back before 2019, our office created a sexual violence task force composed of subject matter experts in our area, where we had the DA's office, survivor advocates, we had the crime labs at the table, law enforcement, to try to craft solutions to address what we were seeing in our state. The Lavinia Masters Act since then, and because of the funding that this House and the legislature has appropriated, has essentially eliminated one of the rape kit backlogs. We still have a few more, but I'm sharing that with y'all because as a result of that, lots of DNA has been tested. And from the DNA testing, we are finding that cold cases are being solved. And while they're being solved, certain statute of limitations in certain cases cannot be prosecuted because the statute of limitations passed. And here's what the law says. So there's a current 5-year statute of limitations for the offense of burglary of habitation with intent to commit sexual assault. And so even if evidence has been processed, they have, law enforcement has what they need, they cannot charge these specific offenses, which is a first-degree felony. So quick additional context, every year, on average, there are more than 18,000 sexual assaults that are reported. That's been about the same. We know that not every rape is reported. So the narrow gap that we're fixing here is that short statute of limitations of the 5 years. What this legislation is going to do is essentially remove that in the specific instance where it's a sexual assault or an aggravated sexual assault, and there has been, during the investigation of the offense, biological matter collected that has not yet been subjected to forensic DNA testing. And so that's what it's doing. I'm happy to answer questions, but we have the experts here who can speak more to it. I'm very grateful for what this committee and for what the House has done to really transform. It revealed this issue now because we have the DNA, and this is the solution. And so I reserve my right to close.
All right. Thank you, Madam Chair. Do we have any questions? No. All right. Chair calls Lavinia Bertha Masters. I have you registered as Lavinia Bertha Masters, representing yourself and Hope Saves.
Yes.
Testifying in favor of House Bill 2019. Is that all correct?
Yes, sir, it is.
Okay, go ahead and begin.
I am Lavinia Masters, once again, the namesake of the Lavinia Masters Act that Victoria Niave did an amazing job in helping us clear the backlog. Because I was a victim of that backlog. I was raped at 13 in my home in the Dallas area. Someone violently raped me at knife point, and my evidence sat on the shelf for over 20 years. I didn't have any answers. I didn't know who it was. I didn't know why this person chose me. But what I realized was after I decided to figure out how to find resolution, that my kid was not only sitting there, but I had missed 2 statute of limitations because of this. And with that, my story, it's heart-wrenching to me. Sometimes it's still heart-wrenching for others to hear. But with this bill, what I want to say is that we can't stop the sinister acts that these monsters do when they rape victims of sexual assault. So I've reshifted my focus, and that's to go back into the pits and let's rescue those victims that are still remaining there, that are still lost, that are still crying out that I need to be saved. And this statute of limitations that's causing this rift for these cases is our way of going back into that pit. And we're saying to those survivors that you matter, your voice matter, your stories matter, that you are important, that we see you, that we care about you in the great state of Texas. and we're going to do all that we can to make sure that your healing is available, that you are made, have the opportunity to be whole after this traumatic experience, because it's very damaging to have to go through sexual violence, and it's even more damaging to realize that you can't prosecute because of something as a statute of limitations. To understand that I missed 2 statute of limitations, I almost went ballistic, but I decided to take that energy and fight another way, and that's by being a voice for other survivors of sexual violence and helping them realize their voice has power, and that we have to speak up and we have to share our pain, no matter how painful or traumatic it is, because people have to understand us. And to understand us, you have to see us, and seeing us is listening to us and listening to the stories that we have to tell. Nobody should have to go through the things that we go through as victims of sexual violence, especially a child at 13, thinking that my system, my justice system, my police officers were searching for me high and low to bring closure to me. So I stand here in full support of this, that we fix the loopholes, any gaps, we prioritize our victims in the state of Texas. We have been doing an amazing job so far, and we shouldn't stop now. And any questions, I'm here to answer them.
Yes, ma'am. Thank you very much. Members, do we have any questions? No. Thank you so much for your time.
Thank you.
Chair calls Amy Derrick. I have you registered as Amy Derrick, representing yourself and the Dallas County District Attorney's Office. Is that correct? Oh,
Correct.
testifying in favor of the bill.
That's correct. I'm Amy Derrick. I'm from the Dallas County District Attorney's Office. I am here in favor of this bill, and I'm the Administrative Chief of the Child Abuse Divisions and the Sexual Assault Divisions of the Dallas County District Attorney's Office. I've been a prosecutor for almost 19 years this October, and I have been exclusively prosecuting child abuse and sexual assault cases for over 16 years. I am a member of the task force that we heard from the representative earlier, and have also worked with Ms. Masters, and I hate that I have to follow her, frankly. But this bill is very simple. In 2014, our county began the laborious task of trying to clear our sexual assault kit backlog. And along the way, we've learned a lot of things. One, that we should have done better years ago, but that we're trying to do better now, and this is one way that we can do so. As it stands right now, someone can enter someone's home, they can sexually assault them or attempt to sexually assault them, and if they aren't prosecuted within 5 years, that case is dead. That shouldn't be. Just because it's titled burglary of a habitation does not mean that it's not a sexual offense. And so what this bill does is it equalizes the sexual offenses across the board and ensures that we can prosecute them all equally. As we all know, there's a myriad of facts and circumstances involved in these types of cases. And prosecutors should not be hamstrung and have their hands tied when it comes to charging decisions simply because of the title of an offense. And so that's why we're here today and asking that you please vote for this bill. Thank you.
Thank you very much, Amy. Members, do we have questions? No. Thank you so much for your time. Is there anyone else wishing to testify on for or against House Bill 2019 at this time? The chair sees none and recognizes Chairwoman Niavi Corrado to close on the measure.
Thank you, Chairman. And I want to thank Ms. Amy Derrick and Lavinia Masters. They're incredible. They're on the forefront of this battle and really have made tremendous change on the lives of people in our state. And we were able to do that because of the support of this Texas House and this legislative body. And so I'm very grateful and hope that you will support this House Bill 2019.
Thank you so much. Members, do we have questions before? Yes, Representative Bowers.
Yes, thank you, Mr. Chairman, and thank you, Representative or Chairwoman Niavi Corrado. It is wonderful to see you further your work when it comes to the backlog and the rape kits, and I supported you fully back in 2019. It's good to see Ms. Masters really advocating for others, using her voice. So thank you for bringing her forward again. I don't really have a question, but I do feel like, and you certainly can answer this, that this will help because we know every kit on those shelves represents a life and a victim. And I think that's the one thing that really spoke to me back in 2019 or even before. When I watched you and witnessed you work on this. So thank you. I look forward to supporting you this legislative session on this and seeing where it goes. And I hope it goes to passage.
Thank you. Thank you for your support.
All right. Thank you very much.
Thank you.
If there's no objection, House Bill 2019 will be left pending at this time. Is there any objection? Chair hears none, and House Bill 2019 is left pending. Chair lays out House Bill 3660 and recognizes Representative Vasut to explain the measure.
Good afternoon, Mr. Chairman, Vice Chair, members of the committee. Thank you for the opportunity to lay out House Bill 3660. 2007, the legislature enacted a cruelty law related to non-livestock animals. And one of the classifications in that law was a definition of the term abandon of a non-livestock animal, which includes a stray cat, and has provided that if you abandon a stray cat unreasonably, you can be subject to a Class A misdemeanor. Fast forward to the present. About 6 months ago, the city of Pearland in my district was interested in permitting a program known as Trap, Neuter, Return in its jurisdiction. If you're not familiar with that program, that basically involves trapping a stray cat, sterilizing the cat, providing it medical care, vaccinations, and then re-releasing it back into the wild as a form of population control. This has been done for decades. However, a question arose while Pearland was studying adopting that ordinance about whether or not trap, neuter, return constitutes unreasonable abandonment under the cruelty statute. I would say that pretty much probably the legislature didn't intend that, but as we know from maybe some of our other committee meetings, Mr. Chairman, what the legislature says is what the legislature says, not what we intended. And so House Bill 3660 is a simple fix that ensures that those that perform trap, neuter, return programs will not be prosecuted. It'll be a defensive prosecution for unreasonable abandonment because it's not unreasonable abandonment. And there's very clear definitions about what a trap, neuter, return program is. Trapped, stray cat, evaluated by a veterinarian, if unvaccinated, vaccinated, if unsterilized, sterilized, and then marked and then returned. And that's what TNR is right now. So very simple bill, but a very profound bill because otherwise, if this statute is ambiguous, we could have thousands of Texans who could face Class A misdemeanor prosecution for simply controlling the cat population. So this is my cat bill, and I'm happy to answer any questions and reserve the right to close.
I appreciate that. Members, do we have questions for Representative Vasut?
I don't really have a question, Mr. Chairman, but I guess no questions today. Mr. Vasut, it is nice to have a cat bill instead of a dog bill. Thank you.
Fair enough. Fair enough.
All right, we do have a few witnesses that
Thank you.
Want to weigh in. Let's see. Chair calls Joseph Stout. I have you registered as Joseph Stout, representing yourself and Mid-Cities Community Cats in favor of House Bill 3660. Is that correct?
That's correct.
All right, go ahead and
Thank
begin
you,
your
Chairman, committee members. I'm Joe Stout. I'm testifying on behalf of myself and the organization Mid-Cities Community Cats, of which I'm president. I'm for House Bill 3660. Mid-Cities Community Cats is an all-volunteer, nonprofit organization that practices trap, neuter, return, or TNR, of unowned stray and feral cats in cities of northeast Tarrant County between Dallas and Fort Worth. Our area of operations includes parts of Representative Bojani's district. It borders directly on Representative Schatzline's district, and we have partnered in our organization as Representative Cook's district. TNR is an effective way of controlling feral cat populations. It has replaced an outdated, inhumane method that's trap and euthanization, which doesn't work. It has over decades. It is feral and stray cats are still there. Return cats are territorial, and they'll keep other cats from coming into the area, and it's proven over time that the population will decline and eventually go away. TNR is about having less cats in our communities. It's not about having more cats. Mid-Cities Community Cats, TNR's about 1,000 cats in our community each year, and we've fixed more than 6,000 cats to date. In doing this, we've prevented tens of thousands of unwanted kittens from being born. And we're just one of hundreds of groups and impassioned individuals in the state of Texas that do this work. TNR helps city animal shelters by reducing their workload and the expense of picking up community cats, holding them for the required period of time, then euthanizing them and disposing of them. TNR programs and their dedicated, passionate volunteers save tax dollars and allow animal control officers to do more productive work. Just to clarify, abandonment means dumping a pet cat or dog in a place where it will not know how to survive. These community cats have outdoor homes and they know how to live there. If TNR is interpreted as abandonment, it'll put a stop to all of this life-saving work. It'll be a sad day for cities and shelters that benefit from these programs, for the taxpayers who don't want their tax dollars being used to needlessly kill healthy cats, for public health, because all these cats will be out there not vaccinated, as they are now in the TNR program, and then for the cats themselves, as thousands more kittens will be born only to die or to live cruel lives of relentless reproduction. So please, I urge you to vote yes for House Bill 3660. Thank you.
Thank you very much. Members, do we have questions? No? Thank you so much.
Okay, thank you.
Appreciate your time. Chair calls Jamie Cantrell. I have you registered as Jamie Cantrell, representing yourself and Texas Animal Control Association in support of House Bill 3660. Is that correct?
That is correct.
Okay, go ahead and begin your testimony.
My name is Jamie Cantrell. I'm the president of the Texas Animal Control Association. We represent officers and animal welfare personnel all over the state of Texas. We are asking for your support of this bill for several reasons. One, we primarily believe that local jurisdictions are best suited to make the choices on what is appropriate way to handle populations within their own jurisdictions. And this bill ensures that TNR remains an option to where we can utilize that to more humanely deal with the feral cat populations that we have. It also is a public health bill. By ensuring that all of these cats ended up having their vaccinations, primarily the rabies vaccination, that helps create a barrier between the human population and the wildlife, primarily skunks and bats, that are the reservoir species for rabies in our state. Because cats that are out running loose, they will interact with bats, they will interact with skunks as well, and if they have come across the wrong ones, those cats can come into our neighborhoods and around our families, around your cats that may be outside, and bring that into your house. So this is a very important public health issue. It also is the most fiscally responsible way to deal with these cat populations. In the economic downturn of 2008, my city looked at every single service that we provided to the community to determine if there were any that were redundant or that were a waste of resources. There was exactly one that was chosen for elimination, and that was the indiscriminate trapping as a means of population control. And at that time, it was estimated to be costing our city about $125,000 a year. It would be closer to $200,000 a year in today's dollars. So by getting rid of that trapping and elimination, as was always used in the past, this is a more humane way for us to be able to move forward and control those populations in a much more fiscally conservative way as well, to where we don't have wasted money, we don't have cats that are needlessly euthanized, and we also have a healthier community of populations. Our officers that we represent are the ones that go out and enforce the abandonment issue on the people who are dumping their pets. We are not the ones who commit abandonment. So we hope that you will support this bill. And with that, if there's any questions, I'll be happy to try to answer them.
Thank you very much. I appreciate your time and sharing with us your expertise on this. Do you have any questions? No? Thank you. Chair calls Mayor Hartzell. Is it Mara? Mara.
Thank you for the opportunity.
I have you, as Mayor Hartzell, testifying on behalf of yourself and Texas Pets Alive in support of House Bill 3660. Is that correct?
Yes, sir.
Okay. Go ahead and begin.
Okay. I'm a certified Texas Animal Control Officer, former director of a Texas municipal shelter, and now work as an industry consultant. In 2020, the shelter I managed successfully completed its first ever TNR pilot program and later passed protections for community cats into law. As a consultant, I encounter up to 50 animal shelters each quarter, most of which are in Texas. This allows me to observe need patterns and what true solutions look like in many different communities. In my former jurisdiction, and in every jurisdiction I work with, trap, neuter, return programs are the best tool for humane cat population management. Stifling these programs is endorsing and ensuring the return of catch and kill methods of the past. Catch and kill methods are inhumane and do not work. My experiences involving cities that choose to remove and/or eradicate community cats rather than embrace modern solutions are all the same. They find themselves repeating a no-win cycle year after year, which also becomes more difficult to perform as time goes on. In this cycle, animals die for no reason. Humans ordered to kill them fight compassion fatigue, and cities struggle to fill key positions at their agencies once those humans burn out. What's known as the vacuum effect moves new cat populations into areas temporarily cleared by catch and kill methods, often within just 12 months. Almost instantly, this puts everyone right back where they started. No one can tolerate that kind of cognitive dissonance for long. The only efficiency demonstrated by catch and kill is truly its brutality. TNR programs are not only the most humane option, but also the most practical. Regardless of one's feelings toward cats, TNR is the most logical, sustainable, and financially conservative long-term strategy that wins the trust and confidence of taxpayers. That's because TNR gets results and frees cities and counties from cycles that cost more money and morale. Value here should be underscored, especially at a time when the economy is at the forefront of everyone's mind. When community leaders choose to embrace humane alternatives to killing, they not only make good business decisions, but also open themselves up to a never-ending well of community compassion. These public-private partnerships pay dividends to administrations in more ways than one, such as through brand equity, political capital, and community engagement. In 2021, for example, 1 year after its TNR ordinance was passed, my shelter received unprecedented support in many ways, and over $100,000 in monetary donations alone, all thanks to the safety nets we created, such as TNR. Committee members, I respectfully request that you take all of the concrete and meaningful benefits of TNR programs into consideration as you deliberate House Bill 3660. Thank you.
Thank you very much. Members, do we have questions? No, thanks so much.
Okay, thank you.
Chair calls Shelby Boboski. I show you registered as Shelby Boboski, representing yourself and the Texas Humane Legislation Network, testifying in favor of House Bill 3660. Is that correct?
That is correct. Thank you.
Go ahead and begin.
Thank you. I would also like to start my testimony and recognize you, Chair Moody, as you were the author in 2017 when we last strengthened the animal cruelty law, specifically Section 42092 of the Texas Penal Code. So on behalf of the 50,000 members throughout the state of Texas, THLN would also like to thank Representative Fasut for bringing this bill to support our 800 plus shelters and thousands of people who perform trap, neuter, release, return on a daily basis. So some of our rural shelters are looking for clarifications on the term abandonment under the Texas Animal Cruelty Law. And it's as follows. If they apply the typical TNR style program under the scope of 42092B4, returning the cat back to its original location may be seen as abandonment. I'd like to give the perspective behind the Texas Animal Cruelty Law. So in 1997, THLN assisted in passing the original Texas Animal Cruelty statute, and the law has been incrementally strengthened in 2001, 2007, 2011, and 2017. In the original statute, the following was included: abandons unreasonably an animal in the person's custody. And so ACOs and shelter professionals testified that the challenge of dogs being dumped in urban and rural areas alike, instead of humanely relinquishing them to the nearest animal shelter. So unfortunately, the illegal act of dumping dogs is still happening, but irresponsible pet owners are now caught more frequently due to technology, game cameras, and cell phone cameras. I teach animal law at SMU as well as wildlife law. One of the perks of being an adjunct law professor is access to law students. So my law students and I went back through all the legislative history on the animal cruelty law. And I can tell you that nowhere in the legislative intent or history of the Texas Animal Cruelty Statute is TNR considered a form of abandonment. It's actually the opposite. TNR is an industry-accepted best practice for the reasonable management of community cats. Also, abandonment has to be unreasonable, and TNR does not meet the definition of unreasonable. In fact, it's the opposite again. TNR programs are incredibly reasonable. Lastly, we have spoken with many of the Texas animal cruelty units throughout the state, and they agree that this should definitely be a defense versus an exception. I also just spoke with, in my opinion, the guru, Shannon Edmonds, and he agrees. So we really like the bill as is with no changes. Texas municipalities, local governments, animal rescues, nonprofits, and the public really need to legally engage in TNR without violating the Texas Penal Code. It was like herding cats, trying to get everyone to come to a TNR definition, but we did it. So again, if we could have your support in passing the bill as is. Thank you.
Thank you for putting time and energy into that effort. I know that getting the language precise is a challenge sometimes. Anybody do have questions? Any members? No? Thank you so much.
Thank you.
Is there anyone else wishing to testify on for or against House Bill 3660 at this time? Chair sees none and recognizes Representative Vasut to close on the measure.
Thank you, Mr. Chairman. Thank the witnesses for providing some context to this. It's a pretty simple bill, but an important bill because TNR is a good program and it shouldn't constitute abandonment. And I think we need to make that crystal clear to make sure that our laws don't catch people up in our jails for good. They're doing good things. And so I'd urge you to support it. You've heard many reasons why. I mean, if you're fiscal conservative, this is, the bill for you. If you're pro-public health, this bill is for you. If you love cats, freedom in the American way, this bill is for you as well. So with that, thank you for your time, and I appreciate your favorable consideration.
It's covering all the bases. Hold on, Representative Morales has a question.
I thought I'd try to get out of here fast.
Or a cat pun. I'm not sure exactly what's
No, I just want to commend you on this bill. You may not know this about my district, but we are just plagued with stray animals. As a matter of fact, there's some cats that go through my backyard every few minutes. I wouldn't even say every hour, but just, and so we've utilized this program, but the cat knows how to get out of the trap, so we're trying to get around that one. So I appreciate you bringing this bill forward. I'm fully supportive of this bill, and I thank you because not only is it a public health issue, but it's a quality of life issue, especially in a community like mine where we do have a lot of stray animals.
Absolutely. Thank you.
Thanks. Members, any other questions? No? Thank you.
Thank you, Chair.
If there's no objection, House Bill 3660 will be left pending. Is there objection? The chair hears none, and House Bill 3660 is left pending at this time. Chair lays out House Bill 2338 and recognizes Representative Lopez to explain the measure. Thank you for your patience.
Thank you. Thank you, Chairman. Thank you, members. So I'm here today to talk about the importance of reimbursement fees for law enforcement services. We all know that law enforcement is an essential part of our life and for our safety and our society. However, our current system right now of law enforcement includes fees that are paid to the peace officer, which can place a heavy financial burden on taxpayers. That is why reimbursement fees are an excellent way to help reduce the cost and shift some of the burden to those who have been found guilty of a crime. Reimbursement fees cover the expenses incurred by law enforcement agencies to investigate, prosecute, and detain individuals accused of a crime. This approach ensures that taxpayers are not left solely responsible for the cost of criminal proceedings. The defendants who have been found guilty of the crime will have to bear some of the costs incurred during the investigation, prosecution, and detention that is done. By requiring defendants to bear the financial responsibility for their criminal conduct, taxpayers can avoid paying the full cost of criminal proceedings, which since 1999, there has been a total of $12.5 million cost for taxpayers. This in turn can help reduce the burden that you as taxpayers and us have to pay for these essential services. So in conclusion, my bill asks you to consider passing this so that we can cut the costs on taxpayers and put the burden back on those that have been charged with a crime. I'm here if you have any questions, and I also have some public testimonies as well that can answer questions.
Do I have questions for Representative Lopez? Would you like to haze your fellow freshmen, or how does it work with y'all? I don't know.
This is already my 8th.
I was gonna say, this ain't her first bill. You know how I know?
No.
Because of one of the witnesses she had come down here. She's very savvy in how she's laid this out. We'll go ahead and reserve your right to close. Oh, do you have a question? Oh, now you're in trouble.
Quick question, Representative Lopez. So this fee goes from $50 to $75, right?
Correct, yes.
And so it's for misdemeanors and felony. But I think misdemeanor C is separate, right? Or is it?
Yes, that's
they're
separate.
separated, right?
Misdemeanor Cs are $50, and felonies, misdemeanors As and Bs are $75.
Yeah.
And currently, the actual fee is $90. And so this would alleviate some of that burden.
Okay. And maybe, again, excuse my ignorance in criminal law or procedure. Is it okay to lump together misdemeanors and felonies with that same charge, or it should be sort of more higher for felony than a misdemeanor?
So, so it does break it down to where the higher charges are the ones that are paying the $75. So the least charge, which is the misdemeanor C, that's the one that pays the least.
Got it. Awesome. Thank you.
All right. So we have a couple witnesses, so.
Thank you.
Reserve your right to close. Chair calls Oscar Ugarte. This is how I know she knows what she's doing. She brought a constable from El Paso. So now I can't say no to him because I have to deal with him back home. I have you registered as Oscar Ugarte, representing yourself and the Justice of the Peace and Constables Association in favor of House Bill 2338. Is that correct?
Yes, sir.
All right, go ahead and begin.
Good afternoon, Chairman and committee members. My name is Oscar Ugarte. I am a constable in El Paso County, constable for Precinct 1, and I'm here in support of House Bill 2338, and I'm representing myself and the Justice of the Peace and Constables Association of Texas. I'm here today because I want to share the work that goes into when we actually go out there and try to execute a warrant. Once our office receives a warrant, our civilian staff and deputies try to do some research and assessment of each warrant before we actually go to the residence and attempt it. The reason we do this is we want to make sure our deputies are safe and what kind of resources we need to take out there. So we do a research on the subject. Has he been violent towards officers? Is known weapons in the house, the residence? Is there any other offenders out there, maybe outstanding warrants from other people that actually reside in the same residence? So we want to make sure we gather all this information before we send our deputies out there to execute these warrants. Once the deputy's out there, a supervisor or a senior officer determines if more than one deputy is needed to actually go to the residence and attempt to execute this warrant. So now we're not just sending one deputy, we're sending 2, 3 deputies, different types of resources depending on how aggressive this offender is. So definitely those resources have increased on the amount of time. Also, in 24 years, I think we can all agree that everything has gone up. The last time these fees were increased was in 1999. Salaries have gone up, insurance on deputies have gone up, the fuel, maintenance on vehicles, and traffic. Traffic has increased. Once the defendant actually is apprehended, the time it takes to book these individuals into the jail, there's a backlog to process these individuals, so the deputies do spend a lot of time inside the jail. And we're not always successful the first time that we try to execute this warrant. So sometimes we have to go 2 to 3 times to each residence. And if we have good information or leads, we'll attempt it more than 3 or 4 times to try to put these offenders back in jail. And I'm asking you not to look at this as an increase, just as a catch-up, because these fees have been neglected for the last 24 years. So I'm asking for your support of House Bill 2338.
All right.
Thank you.
Thank you, Constable. Members who have questions? Thank you for being here. Chair calls Chad Jordan. I have you registered as Chad Jordan, representing yourself and the Justices of the Peace and Constables Association of Texas in favor of House Bill 2338. Is that correct?
That is correct.
Okay, go ahead and begin your testimony.
Chairman Moody, Vice Chair Cook, distinguished members. My name is Chad Jordan, Constable, Hood County, Precinct 4, Lake Granbury, Texas. Secretary Treasurer, JPCA. JPCA, we also represent the largest association of elected officials in the state with over 2,000 members. We've looked at the warrant fees in years past and things that have happened, and we've tried to recoup money that is not taxpayer funds. This is not funded by the state. These are things after the fact for individuals that are found guilty. That's the good thing about it. These individuals need to pay for those services that are rendered. And in that, in taking conservative numbers when we look at it, out of the 1.46 million arrest warrants on the low side that we have in the state, you take 550,000, we have $13.7 million shortfall to Texas counties. That adds up over time. We talk about manpower, we talk about the cost of retention, of trying to keep people, to keep officers, vehicles and outfitting those. Just from last year alone to this year is a $20,000 increase just in the price of one vehicle. That does go to the taxpayer. But if we can find ways that these defendants are paying for those things is what it's about. Another thing it looks at, these warrants are a critical component, annual collection of $255 million of criminal court fines and fees. OCA worked hard with the state of Texas roughly 20 years ago. We're having budget shortfalls. How do we look at these things? Well, these are one of the things that we didn't look at, that the defendants, the individuals that commit these crimes, being held accountable for that. And this is why we ask for your support in this House Bill 2338. And I'm here to answer any questions you might have.
Members, do we have questions? No.
Thank you so much.
Appreciate you. All right. Is there anyone else wishing to testify on, for, or against House Bill 2338 at this time? Chair sees none and recognizes Representative Lopez to close on the measure.
Thank you, members. And with this, I ask you to refer this bill to the full House with a recommendation that it do pass and that it be sent to the regular calendar. Thank you very much.
Thank you, Representative. Do you have questions? No? Thank you. If there's no objection, House Bill 2338 will be left pending at this time. Is there any objection? Chair hears none, and House Bill 2338 is left pending. Let's go ahead and, oh, there's Reggie, okay. Chair lays out House Bill 3956 and recognizes Chairman Smith once he catches his breath.
Yeah, thank you.
To explain the measure. Do we
make the run over here?
We don't have a sub on this? Okay, all right.
I appreciate y'all's time, Chairman.
Yes,
Thank
sir.
you, Vice Chair, members. Real pleasure to be able to lay this bill out for you. Ladies and gentlemen, in 2019, we passed House Bill 1399. That was my freshman session. This legislation expanded the collection of DNA samples upon the arrest of certain offenses, primarily those that are assaultive in nature. Once the sample is taken by a local booking agency, it is sent to the state lab where it is compared with other samples in a database. At this point, law enforcement agencies can compare the samples and connect the offender with any other open case or cases. We should all be very proud, those of us who were able to vote on that bill that day. We should all be very proud of the success that has come from HB 1399. Due to the passage of that legislation, the use of DNA collection has aided in the investigations of 615 sexual assaults, including 248 in fiscal year 2022, as well as 109 sexual assault of child cases, 35 of which were also last fiscal year. In addition, this technology has helped solve 363 burglaries, 104 aggravated assaults, and 66 thefts in the last 3 years alone. Year after year,
we are seeing an increase in cases solved due to the collection of DNA samples. Since 2019, there have been a total of 1,519 offender to case hits collected. Some of these cases include an offender arrested for murder in the Houston area who was connected to 2 sexual assaults in that very same county. In fiscal year 2021, an offender arrested for sexual assault hit was connected to 3 other sexual assaults. One of those dated back to 2002. And just last year, an offender arrested for smuggling of persons was connected to 3 unsolved sexual assaults. These examples, combined with the data mentioned previously, show how HB 1399, that's the bill we passed back in 2019, has been a vital tool in solving open cases. Currently, 18 other states collect DNA samples for all felony arrests. These states include our neighbors, Louisiana, Arkansas, Oklahoma, and New Mexico. It is time that we, as a state, modernize and match these tools and technology. Along with expanding DNA collection to include all felony arrest, this bill, HB 3959, strongly focuses on clarifying the process in which a individual's record is expunged once the court provides notice of an acquittal, a dismissal, or grant of relief. Mr. Chairman and members, I would like to stress the importance of this legislation. We have an opportunity here to pass into law policy that will make our kids, our constituents, and all Texans safer. The offenders affected by this bill are truly the dangerous and repeat criminals that must be taken off the streets. Now is the time to realize that DNA collection is the fingerprinting of the 21st century. Just like a fingerprint used to be, DNA is now the fingerprinting of the 21st century and is the next step in using technological advances to assist law enforcement agencies in solving crimes. Members, let's work together and use this technology to build a safer Texas. But let me also point out to you that it's not just convictions. It's not only just bringing justice to those who are offenders, it's also bringing justice to those who do not deserve to have been convicted, because there is an acquittal facet to this. Because once you find the true perp, if there's someone else who has been convicted or is charged in connection with that, then you get to, you acquit them, you free them. So it works both ways. It works both ways. The other thing I would like to point out to you is I am not aware of one circumstance in Texas or in any other state where there has been a misuse of DNA material, if that's something you're worried about. It's something we talked about in 2019. Since we implemented this in 2019, I'm not aware of one circumstance like that. Whenever I argued the bill in 2019, I was not made aware of another circumstance that had happened in any of these other states. So what we have truly is a unique opportunity here, all of us together, to make Texas a safer place. And I appreciate the opportunity to present this bill, and I reserve the right to close and would love to take any questions that you may have.
No, Chairman, thank you. I appreciate all the work you've done on this issue going back some years. I will tell you the conversation has changed drastically. If I'm looking at my registration stats correctly, based on where we had this a couple of sessions ago, I don't see anybody here that is coming to oppose your legislation. So I look forward to hearing the folks talk about why it's a good thing, but we're gonna have a one-sided conversation based on the work that you've done, so.
Well, to be fair to everybody, back in those days, we didn't have a track record.
That's true.
Now we do. And so I appreciate the opportunity.
Thank you. Oh, yes, Chairman Darby.
Thank you. Question on the fiscal note.
Yes, sir.
Have you seen it?
I have.
Substantial.
Yes, sir.
Just talk to me a little bit about the process and why is that a fair assessment of what you think the program costs would be?
So, Chairman, there are ongoing conversations about that. We just got that fiscal note yesterday. I've been having really productive conversations with DPS. I suspect that they're here today to kind of clarify some of that for you. I do know this, for each one of these kits, it's about $45. And if we expand the bill to include all felonies, they anticipate somewhere around 100,000 of these every 2 years that we'll have to process at $45 a piece. Then on top of that, there may be some FTEs that are necessary to be able to do that. And the thing you try and balance, Chairman, is you try and balance the need for the employees to transmit these things with how quickly you get them transmitted. Because if the quicker you can get the information uploaded for law enforcement to make the matches, the safer people are. So if you don't have enough FTEs and you have a big backlog of these samples from these arrests, then, you know, there's still time for these guys to be out there running around. That also means that there's still time for someone to be wrongfully accused.
Well, we're all painfully aware of the rape kit backlogs that we have, and
yes,
that would not be if we're going to go down this path, then we need to make sure we have the money to do it right and do it timely.
I think you're right. I think it is a unique opportunity that we have with our budget surplus at this time, but I mean, I know that the technicalities on that. I would just say that, and I don't want to be overly dramatic about this, we spend a lot of money on a lot of different things around here, okay? I may be a little biased, but I think there are very few things that bear fruit like this does. When you think about, there are young, particularly women, there are young women out there right now who we may save from a rape because we spent the money on this bill. And so I think it's something that if,
Would you speak a little bit and elaborate on the need to timely remove that DNA from the record upon the defendant's acquittal? Is that simply an effort to address First Amendment issues? Or, I mean, it seems to me like once that DNA is in the database, it might be helpful and necessary for future detection of crimes. So just talk to me or talk to the committee a little bit about why you're doing it that way and why do you see that as necessary?
I think trying to balance the competing interest on this and the competing voices and to as a show of good faith, to make an effort to have what is the most balanced piece of legislation that we can have. I felt like that was probably a good approach to say, hey, if you enjoy a presumption of innocence and you have a right to a jury trial and you are acquitted by your peers, or there is a writ of habeas corpus that comes back saying that, you know, you weren't given due process or that sort of thing, then so we remove your DNA from that to try and balance those equities. But I'm willing to listen to other people's input on that. If people have different opinions on that, and certainly we can try and make it a better bill.
Okay. Thank you, Mr. Chairman.
Yes, sir.
Any other questions, members? No, we do have a number of witnesses. Let's start with Chair calls Brian Hawthorne. I show you registers Brian Hawthorne, representing yourself and the Sheriff's Association of Texas in support of House Bill 3956. Is that correct?
Yes, sir. Thank you, Chairman.
Go ahead and begin your testimony.
I hate that I'm first because you got a whole lot of people that are better witnesses than me. Here's what I will tell you. We don't believe you can put a price. I'm Brian Hawthorne. I'm here for the Sheriff's Association of Texas. We have been in support of this bill from the inception, well over the last 10 years of moving forward with this DNA. We don't believe you can put a price on the pain of victimization. So to me, $7 million a year is bug dust if it means putting serial criminals away where they can not continue to their criminal behavior. So I will be brief. You know, currently we do 24 felonies in the arrest. It's been a very successful program with offenders and arrestees doing about 60,000 samples a year. And of those 60,000 samples, 1,300 of them are identifying hits of potential criminals. So if this bill moves forward, which I sure hope this committee will move it forward, we'll be looking at about 105 collected samples, 105,000 collected samples, and hopefully getting anywhere between 2,200 and 3,500 samples. I know that Brady Mills from the DPS lab is here, and he can obviously speak to those numbers a whole lot better than I can as a sheriff. When this first rolled out, it rolled out a little slow. Sheriffs will take some responsibility for it. We had sheriffs that were collecting, say, 40 to 45% of their samples. My sheriff's office was getting 70. We had one sheriff's office that was collecting 91%. DPS has worked with us well, training and educating us on exactly when we need to be taking the samples. So we feel like the program is kind of like a snowball. It's growing and it's going to get better, and it's going to get stronger, and it's going to take more criminals off the street. I'm going to stop right there and be very brief, because I know that there are some district attorneys and some people that have been victim to some of these crimes that are here to speak to you. But from a Sheriff's Association perspective, we are primarily the ones that do the work, that we take the collection as the Sheriff's Office, and we support this, and we want you to figure out ways to fund it and help DPS and help sheriffs put criminals in jail. Thank you.
Thank you, Sheriff. Chair calls Cheryl Leak. I have you registered as Cheryl Leak, representing yourself and the Chambers County District Attorney's Office.
Yes.
In support of House Bill 3956. Is that correct?
Yes. Good afternoon. It's good to see you, Chair Moody, again. Good afternoon, members. Thank you for this. I am the District Attorney for Chambers County, and I am in support of this bill, House Bill 3956. And I also would like to thank Chair Smith for being such a supporter of this legislation since 2019. And you're going to hear from Ashley Spence, who is a sexual assault survivor, and I thank her for her courageous advocacy all these years. In 2019, after 4 tries, we passed the Crystal Jean Baker Act, which mandated the defendants be swabbed and their DNA loaded into CODIS for 24 enumerated felonies. In 1996, 13-year-old Crystal Jean Baker was raped and murdered, and her body was thrown under the Trinity River Bridge in Chambers County. That case remained unsolved until 2010. And in 1996, when this happened in my county, it was my second year as an assistant district attorney. Her assailant's DNA was located on her dress and under her fingernails, but investigators could find no match in any database. In September 2010, an offender, Kevin Edison Smith, was arrested in the state of Louisiana for unrelated charges, and he was swabbed, and we got a match. And I just want to reiterate that he was arrested for a Class B misdemeanor, possession of a prescription without a prescription. DNA was taken in Louisiana, and he was matched to our case, and my office prosecuted Kevin Edison Smith for capital murder, and he is currently serving a life sentence. Since the law was passed in 2019, it is doing exactly what it is supposed to do and exactly what we predicted it to do. It is solving crime and bringing closure to families of victims and testing just 24 felonies in the first year. 243 cases were closed, and the numbers have increased every year since then, as you've heard from Chair Smith, and it is also exonerating the innocent. What House Bill 3956 does is it designates the booking agency, which will be the local sheriff, as the person responsible for taking the sample. This will increase compliance. As Sheriff Brian Hawthorne stated, we have not had 100% compliance because there was some confusion as to who was supposed to be taking the sample upon booking. But even without 100% compliance, these statistics speak for themselves. And it mandates that a sample be taken for all felony arrests. When other states, such as New Mexico, began testing all felonies, their match rate went up 83%. It's also important the bill clarifies the DPS's lab's duties and responsibilities in regards to expunging results out of CODIS when a case is dismissed or a defendant is found not guilty. And as our sheriff said, Brian Hawthorne, we're talking about the fiscal note, and I know that's always a concern, but the bottom line is serial criminals do not stop, and you cannot put a price on victims and their lives. I have been doing this, I have been prosecuting for 28 years, and people who commit most felonies do not stop, especially the sexual felonies. They are not going to stop. The only way to stop recidivism is by passing this law, by passing this bill, and making sure that all felons are swabbed upon arrest. I will take any questions.
Cheryl, thank you very much, and I appreciate your passion and all your work on this throughout the years. Members, do we have any questions? No? Thank you.
Okay, thank you.
No, I got that. Chair calls Lavinia Bertha Masters. And I just need to clear up for the record.
And there twice.
I've got you in there twice, so pretty easy to clear up.
Yeah.
I have the registration with your, that I recognize you as Lavinia Bertha Masters, representing yourself and Hope Saves for House Bill 3956.
Yes,
there was a duplicate registration that just said self.
Yes.
But you are here on behalf of yourself and the organization. Okay, so we have your permission to delete the other.
Yes.
The other, okay, gotcha. All right, go ahead and begin your testimony.
Thank you. Lavinia Masters again, standing before you in favor of House Bill 3956. First, let me say that DNA changed my life, and I say DNA stands for Denied Never Again, because I feel that if you utilize DNA, you will never deny another survivor or victim of any crime the pain and trauma they go through after going through that traumatic experience. And I also say that DNA is a footprint from God. It was created and for us to discover and use just for that purpose of helping others come through the ruts and the pain that they've been through. I had a whole speech prepared, but listening at the beginning. And when we talk about money, and I take that very personal, my life, my sanity, the hope for my future, you couldn't put a price tag on that. And I wouldn't put a price tag on anybody else's life. To me, it just makes sense. It's just common sense for us to do this. My rapist, he started out as a carjacker, and they didn't collect his DNA for that. And he went on to burglarize and rape girls and older women after that. It's just to say it rises something in me, because that's what I heard in the beginning when I started this fight in 2006. It was the money. It was the dollar bills. And I'm like, do we see green versus do we see that person that's standing there, that's in pain, that's hurting, that's traumatized? You will actually put me up against the cost of something versus my life and my sanity. And that's dehumanizing to me. That's disrespectful to me as an individual. And it should be disrespectful to anybody, because if the shoe was on the other foot, you wouldn't want me to say, well, if it don't make dollars, it don't make sense. I would say if it don't make sense, I don't care about the dollars. And that's just the God honest truth. What I care about is that I care about people. I care about them having hope. I care about their futures. I care about them seeing life beyond tragedy and trauma, because it happens. There are sinister people in this world. There are evil people in this world, and we cannot change that no matter how we pray. And I'm a woman of faith, and I believe in prayer, but I also believe in healing, and I believe in hope. And this is what we give back when we say as a state that we're going to do whatever it takes, whatever it costs, whatever it may be, to make sure that you feel safe. And if you do encounter trauma or pain or whatever, a victim of rape or any kind of crime, we are here to help save you, bring you back to life, give you opportunities of hope. And that's just how I feel about that. I'm sorry, I didn't mean to offend anyone or seem like I'm being aggressive with anything, but that is something that I heard for years. It was the money, Lavinia. It was the money. I am more valuable than any dollar bill, and I mean that. And everybody that I feel in this room is more valuable than any dollar bill. And I know that we should all have the same mindset when it comes to DNA and making sure that we keep our streets safe and we protect our children and our grandchildren and when we're not here anymore. And that's it.
Thank you. Thank you very much for your testimony. No
Have any
one
questions?
no one up here is offended. We're just grateful that you're here sharing your story with us.
Thank you. Thank you.
Members who have any questions? No? Thank you.
Thank you.
Chair calls Ashley Spence. You can go ahead and bring that up. Did you have stuff for us?
Mr. Chair,
Thank you. I'll show you as Ashley Spence, registered, testifying on behalf of yourself and the DNA Justice Project in favor of HB 3956. Is that correct?
Mr. Chair, yes.
Okay, go ahead and begin.
Mr. Chair, members of committee, thank you so much. I'm Ashley Spence, founder of DNA Justice Project, and I stand here in support. I was 19 years old when I was the victim of a very brutal home invasion rape. I was a college student at Arizona State, and I went to bed that night thinking I was safe in my own home. Only this night I wasn't. An intruder came into my apartment, smothered my face with a pillow, and began to rape, beat, and nearly killed me. I endured this torture for hours throughout the night, but physically I survived. But he got away, and I never saw his face. I worked day and night with detectives, but there were no leads, and the fear was paralyzing. I dropped out of school, I moved to Newport Beach, California, and eventually relocated back here to my home state of Texas. It was here in 2010 that I got the shocking phone call. After 7 years, there was a DNA match. And ironically, I moved to Newport Beach to escape this monster, but in reality, I moved to the very city where he was from. When they arrested him, they found him just a few blocks from where I lived all those years. He was arrested for an unrelated offense. He resisted the officer, a felony there, and thankfully in California, they share the law that 18 states have upon all felony arrests, DNA is taken. They took his cheek swab, they uploaded it into CODIS, and it hit a match back to my case all those years before. He was a serial rapist with a wife and a child and a shed behind his home full of women's underwear and ID cards from all over the world. But through the power of forensic DNA and this very law, he is now in prison for nearly 138 years, unable to harm another person again. I have justice, but all victims deserve justice. And the way the law stands in Texas today, he would still be out there today, free to rape and harm other women. Now, CODIS has been around since 1998. We have never had a breach. It is incredibly protected. DNA databases not only save lives, but they save money too. A University of Denver study found that for every dollar spent in DNA, $90 is ultimately saved. Dr. Jennifer Doliak also did a study that concluded for every profile that is entered into CODIS, which ranges between $35 to $45, taxpayers can see $26,000 in savings. By expanding this law, we can build upon the tremendous success that we have already seen seen since 2019. And we can also decrease the occurrence of heinous crimes. In 2000, there was a case of Jeffrey Griffin. He was charged with 8 murders and 1 aggravated sexual assault. Now, 5 years before that, in 95, he was actually arrested for a felony drug offense. Had they been able to take his DNA cheek swab then, it would have connected him to another violent rape in the system. We could have prevented 8 murders and 1 aggravated sexual assault that we know of just by having this law. So it is proven to work, and we know that many of these criminals, they are getting caught on lower level felonies. The most prolific serial rapist in Colorado was caught through forgery. And when we look at taking out crimes because maybe something's too expensive, we can't cherry pick what crimes we include, because essentially we're cherry picking what victims deserve justice. It's essentially like saying, wow, you were raped by a drug dealer. No justice for you. It's too expensive. I'm so sorry. But every victim deserves justice. I know I'm running out of time, but Dr. Wickenheiser, he does a really good analogy of this. He says, we have the opportunity to put an end to rapes and burglaries and murders. They are the criminal flames that are lighting our neighborhoods on fire. But the laws are falling short. The hose can't reach. Today we can come together to put out those fires. And I raised my 2 children in this great state, and this morning my daughter just wanted me to tell you, she's 7, her name's Scarlett, please, please pass this law. And so on behalf of all of our daughters, I just want to say thank you. I know I ran over my time, but I sincerely appreciate all of you and all of the work that you've done.
We appreciate you spending time with us and your patience with us today, and coming forward to testifying, and certainly sharing your story and becoming an advocate and making sure that we're able to stop this in so many other cases is certainly a good goal that we all share. So I want to make sure there's no other questions. Chairman Darby.
Ashley, thank you for your testimony. This data, you know, what I'm having trouble coming to grips is why, once you have the DNA collected, why do we release it or require as soon as permissible that it be expunged? Are other states expunging their records if you're acquitted?
Mr. Chair, Representative.
Charging offense?
Yes, they are. And if you don't mind, could I go through the DNA database super quick? Would that be all right?
Yes.
Okay, thank you very much. So what actually goes into the system? So there's a lot of confusion now, especially with 23andMe. People get very scared, I understand. They think that your whole DNA is going into the system. So the DNA is made up of 3 billion markers, but that's not what's going in there at all. It's merely a DNA profile. So the profile is just made of 20 markers, and I actually have it on my business card. I had my DNA taken. If I were to get arrested for a felony, it's 20 numerical markers, and it wouldn't say that I'm Lebanese, if I'm predisposed to any genetic diseases, what my address is. It doesn't even have your name in the database. All it has is a specimen ID number. So if there is actually a match in the database, what is in there is the profile, just numbers, no name, and the name is kept in an offline secure system. We've never had a breach in it. When there is a match, what happens is they take the numbers, and the person that is in charge, that is authorized to have the name, can only then release the name to the investigative team working the case. So the detectives, they get the info. They can't even use that DNA. What they have to do is use that as an investigative leave. So they use that to support their case. They have to get a search warrant in where they collect the second DNA swab. So the second DNA swab, if there is a match, that is the match that is permissible in court. But again, it's just the DNA profile. And so you will not be precluded from getting a job. People cannot get into the database. Third parties do not have access to this. They can't see your name. But what is public is your arrest record. So, I mean, you have your arrest record, you're taking mugshots, fingerprints, that's all out there, public access, but the DNA profile is not. And it is a federal law that you have to be able to have your DNA expunged from the database. The Office of the Inspector General, they do annual audits on this as well as random audits, and it is completely destroyed if you are found not guilty.
Okay, thank you.
Thank you very much.
Members, do we have any other questions? No?
Thank you. Thank you very much. I appreciate y'all.
Chair calls Eric Carcerano. It's all right. Come on up and then just give us a quick. I show you registers Eric Carcerano, representing yourself in the Chambers County District Attorney's Office in favor of House Bill 3956. Is that all correct?
Yes, Mr. Chairman.
Is there any other comments you want to add to it than that?
Mr. Chairman, it's been adequately addressed by the rest of the witnesses. I urge favorable consideration. Thank you for your time.
Thank you, and thank you for your work on this.
Yes, sir.
Chair calls Brady Mills. I always let the technical experts back clean up, so that way when we're all confused, we can ask you those questions.
Yes, sir.
No, but I have you registered as Brady Mills, representing Texas DPS Crime Lab, neutral on House Bill 3956. Is that correct?
Yes, Mr. Chairman and members.
All right, so go ahead. And I know you've heard some of the conversation amongst the members. If you have any commentary based on those questions, go ahead and give us that. And then if there's any questions from the members, we'll go to those.
Yes, sir. CODIS is a program that we have here in the state of Texas that we partner with the FBI. It's established in the DNA Identification Act of 1994. And so the expungement piece is part of our relationship with the FBI. So we have to have an expungement mechanism for samples that we put into the database. The database, how samples are collected, were well explained by the other witnesses. I would talk a little bit about the sample increase. We are currently processing 60,000 samples per year. With moving to all felony arrests, working with our crime records department, we foresee testing 165,000 unique arrests of individuals. With the 60,000 that we are currently doing, we went ahead and subtracted that out, and we foresee 105,000 new samples collected each year that would be tested for this process. And that's what drives a lot of the fiscal note. So we do have a consumable cost per sample. So that is for the collection kit that the local investigators will use to collect a sample, and then also the consumables that we use in the laboratory to generate the DNA profile. And so that is a big portion of that. And it was well explained by the chair when he laid out the bill that there's kind of a balance about us being able to collect these samples. But our mission is to get these samples completed and uploaded into the database within 30 days. And so the necessity of having additional staff based on the increase of samples is the additional FTEs that we have in the fiscal note as well. And I'd be happy to address any questions that the members might have.
All right. Members? Questions? All right. Thank you so much.
Thank you.
Certainly appreciate you waiting with us. Is there anyone else wishing to testify on, for, or against House Bill 3956 at this time? Chair sees none and recognizes Chairman Smith to close on the measure.
Thank you, Chairman. Chairman Darby, you learn something every day. I apologize. I've forgotten completely about that FBI component on it.
So it's required.
Yes,
It's required by the FBI
apparently.
to expunge.
And I can get you more information on the exact parameters of that. But yeah, for some reason I've
Okay,
in a while.
that explains it. Thank
Yes,
you.
sir. And you've heard it. Scarlett wants us to pass this legislation. So we've got to do it. No, I want y'all to know, I get to be the guy that carries the bill, but these folks, some of them have lived it, and they're passionate about it, and others have been involved in this fight for years and years and years, like Eric, and I just appreciate all that they've done through the years, and they have single-handedly made Texas a safer place with the original bill, and now we're going to continue to I pray, with this, and I just appreciate your favorable consideration, and I close.
All right. Thank you, Chairman. If there's no objection, House Bill 3956 will be left pending at this time. Is there any objection? Chair is none. House Bill 3956 left pending. All right. Chair lays out House Bill 2700 by Chairman Guillen, who is chairing committee right next door. So we're going to try and get you right back to your work over there.
Thank you, Mr. Chairman.
Yes, sir. Please explain the measure.
Members, innovations in technology can facilitate new variants of criminal activity. For example, the production and distribution of sexually explicit visual material involving children using computer imaging software, deepfake technology, and artificial intelligence. The use of deepfake technology and AI has made it easier for predators to create explicit visual material involving children, which is not only morally reprehensible, but should also be a criminal offense. Even though current law prevents children from being directly and physically used in sexually explicit material, There's currently no clarity if the protection extends to computer-generated visuals, and some argue that current statute refers only to visual materials based on actual images of children. HB 2700 clarifies that the creation, distribution, and possession of such computer-generated content is criminal by expanding the definition of visual material to include depictions of a recognizable likeness of a minor created using deepfake technology, AI, or other computer software. This bill sends a clear message that the production and distribution of sexually explicit material involving children will not be tolerated, regardless if it is actual images of children or computer-generated likenesses. By expanding the materials subject to the existing offenses via HB 2700, we can ensure that those who commit these heinous crimes will face appropriate consequences for their actions. And I can help answer any questions if y'all have any.
Members, do we have questions? Chairman, I have one witness is registered. We can close on your bill for you if you need to head back to committee or hang out, your choice. I'm happy to.
I'll hang out.
Okay, all right.
Thank you.
Chair calls Deborah Simmons. I have you registered as Deborah Simmons, testifying on behalf of yourself, and neutral on House Bill 2700. Is that correct?
Yes, that's correct.
Tell me what you just gave me.
I'll be brief. I'm providing comment on this bill. I am providing documentation. It would be a possible amendment for child-like sex dolls to also go on this. It shouldn't matter whether the material is images, videos, or 3D. And so this is a great opportunity to look at child-like sex dolls. So basically, there was a mom that found that her child was imitated on a doll on the internet in 2020. So this problem is definitely happening across the country. Want to get ahead of it. It's already passed in Utah, Tennessee, and Florida. And so this is just an opportunity to share this information with you. I'll be brief.
Understood. So the bill as is does not include that language, but is trying to get at other ways that this essentially this material is being being utilized by folks. I mean, different technology, different things are being out. So your suggestion is there's an opportunity to capture maybe some other conduct.
Absolutely. Okay. Dolls, mannequins, robots, and that's what this language includes.
Okay, I'm going to give this.
I'm being brief. I apologize.
No, I appreciate that. I'm going to give this language to the members of the committee, okay?
Thank you so much.
All right, members, do you have any questions? No? All right, thank you. Is there anyone else wishing to testify on for or against House Bill 27? Oh, did you have a question? Do we have? No? Okay, good to go. And I'll give one to the chairman as well. Anyone else wishing to testify on for or against House Bill 2700 at this time? The chair sees none and recognizes Chairman Guillen to close on the bill.
We'll work on that and get you sub as soon as possible. If there's any questions, I can answer them. If not, I close.
Members? Representative Harrison.
Thank you, Chair. Thank you, Representative Guillen. I mean, the issue that you're attempting to solve here is obviously a problem. Revenge porn is reprehensible and disgusting and vile. But just trying to understand this, because this is kind of a newer area for us as technology has sort of evolved. Does any part of the image that we're describing or contemplating in this bill, does it actually have to be an image of the person? Like, in other words, could the whole thing be drawn or created by a computer and like that the person's image actually never be accurately represented by whatever was created? Like, does a photograph of the person have to be a part of the AI-generated image, or is it just if it's a wholly construed computer generation that like resembles somebody, that's close enough?
That's what we're trying to make sure is in statute. Right now, it insinuates the statute insinuates that you'd have to actually. It would actually have to be of an actual person that is under the age of 18. And so in this case, it could be someone that that is computer generated that looks like somebody that's under the age of 18.
So this bill is scoped only to minors then, is that right?
Absolutely, yes.
All right, thank you very much, Representative. Thank you, Chair.
All right, members, do we have any other questions for Chairman Guillen?
Thank you.
I'll be over there shortly, sir. If there's no objection, House Bill 2700 will be left pending at this time. Is there any objection? Chair is none. House Bill 2700 is left pending. We have come to the point in the schedule that the only bills left are the bills by us. Mr. Leach stepped out, otherwise I'd go with his. Turn us over to Vice Chair Cook.
Whichever one you want to do.
Which one you want to do? No. 23, 26. This one. He said he didn't care. He said he didn't care. Which one? This one. Okay. All right, Chair lays out House Bill 2326 and recognizes Chairman Moody to explain the bill.
All right, thank you, Mr. Chairman. Members, real quick, HB 2326 allows Justice of the Peace to save money on autopsy costs by only having to send off a deceased person's blood to determine if their death was caused by an accidental overdose of illicit drugs such as fentanyl. This does not prohibit Justice of the Peace from sending for an autopsy, but gives another tool for them to use at their discretion. For reference, one Justice of the Peace precinct in Bell County alone spends over $100,000 each year to send deceased persons out of the county for autopsies involving accidental overdoses. Being able to send only the blood to be tested for drugs, that the cost for them would be reduced up to 60%. This measure would also ensure correct manner and cause of death. Testing blood is an effective way to determine whether drugs played a prominent role in the person's death. And obviously, we've heard plenty of testimony about the rise of number of fentanyl-related drug overdose deaths in Texas. And so JPs would have this tool at their disposal as well. This would also reduce inquest completion time. So for smaller counties who don't have a medical examiner, they must send deceased persons out of county for autopsies. Transportation is an issue, logistics are an issue, and autopsy turnaround times increase the time required to complete an inquest. This often results in upset family members, understandably so, and funeral homes that also logistically are going to have issues because they must wait for the body to be returned to the county of origin to perform their funeral services. That's what I have in terms of the presentation on this bill. Happy to answer any questions. I do know that we have some folks to answer more technical questions.
Members, any questions for Chairman Moody? Thank you, sir. All right, the chair calls Judge Gregory Johnson. Judge Johnson, we show that you're registered here on behalf of the Justice of the Peace and Constables Association of Texas, and also on yourself, and that you're testifying for the bill. Is that correct?
That is correct, Mr. Chairman.
All right, thank you. You may proceed.
Well, thank you, Mr. Chairman, and members of this distinguished committee. Thank you for having me here today. I'm Judge Gregory Johnson, and I have the great pleasure of serving as Bell County Justice of the Peace, Precinct 4, Place 1 in Killeen, Texas, home of the great place, Fort Hood, America's Hammer. It is a pleasure to be here today. I am speaking in support of House Bill 2326, as well as on behalf of our fellow members of the Justice of the Peace and Constable Association of Texas. As Chairman Moody laid out in his comments as he laid his bill out, many of you know that in most counties in Texas, the Justice of the Peace is responsible for conducting inquests on deceased persons to determine the manner and cause of death. Now, when we look at Article 49, we have that authority that Justice of the Peace are able to conduct those inquests. Now, when I conduct inquests in my county, there are different measures that I take to gather that information. One, I go out to the scene, I gather information from the body, from the detectives, from the officers on the scene. Also pull medical records, talk to doctors, physicians, and medical personnel. The third option that I use is in the form of an autopsy. Those are good measures, but they are the most costly measure and least time effective measure. If you look at Article 49 of the Texas Code of Criminal Procedure, that's where we get our authority. There is a provision in there that currently allows justice of the peace to draw blood on deceased persons that are involved in motor vehicle crashes. And if a circumstance arises where I think that that person's intoxicated or that alcohol played a cause in their death, then what I can do is that once the portion is completed on scene, and I have the body brought to the mortuary, and then I can sign an order where I will have the blood drawn, and then I will give it over to that detective or that officer, and then they will have it sent to their DPS lab so they can test. And so if this bill passes, it will expand that provision and allow me to also not only draw blood on these deceased persons only, on other inquests. And let me give you an example. I had a young person, 27 years old. He lost control of his truck. He flipped 4 or 5 times, hit a ditch. He flipped so many times that by the time I got there, his driver front wheel was inside the cab of the truck. He wasn't wearing a seatbelt. Well, when I started to do my inquest, it was pretty straightforward. I gathered all the information from the scene, and I had originally determined that it was going to be blunt force trauma, blunt force injuries. But every decedent is searched for IDs and different items that they may have on them, so we can give those back to the loved ones. Well, when the detective searched his pocket, he found marijuana as well as Xanax in his pockets. That raised a red flag. And so I had the opportunity originally to avoid doing an autopsy because it was plain and simple. But since there was drugs located in his pockets, I wanted to rule out that those drugs did not cause or play a part in his death that required me to do an autopsy. Autopsies are very expensive for smaller counties such as myself. And the numbers that Mr. Chairman stated, I would tell you, is that I went back and I asked the auditor to look at our total for all 6 JPs in our county. We spent $848,000 last fiscal year in autopsies. $296,000 of that was spent on autopsies for overdoses, and illicit drugs. And that is a concern to me because I'm home in the great place, Fort Hood, and we have a lot of soldiers there. And we have a lot of overdoses with fentanyl and Xanax. And so what this allows us to do is to use the most cost-effective method, get it right, and determine the proper manner and cause of death. Right now, I'm spending an average of about $3,000, and it's much higher in smaller counties that are far away from metroplexes. It costs me $650 for transportation. I have to put the body in the van. I have transportation that drives them to Dallas to the medical examiner. It costs us $2,250 for a basic autopsy, and then another $500 for toxicology, which is why I'm sending them there in this scenario. And so this will allow me to drop my costs from over $3,000 on this circumstance to just under $1,000. When I ran for this position, I assured my constituents that I was going to do my job to the best ability I could at the most efficient and effective way. And so I would definitely ask for you to support Mr. Moody's bill, and I would definitely stand for any questions that you might have.
Any questions for Judge Johnson? Yes. Representative Morales.
Hi, thank you so much for your testimony today. I am actually a funeral provider in a huge urban district, Houston. So we have the luxury in our city to have a medical examiner's office. And so I applaud you because no one can sign a death certificate who's a non-medical professional except for a justice of the peace. So that leaves you with a huge responsibility. And so I support this this legislation to help you in what you're doing, because it is a very detailed, I mean, there are so many facts and so many bits of information that you have to collect on your own without the luxury of a huge office like we have in Houston, Texas, or in Harris County. So thank you so much. But how do you draw the blood? Do you do it yourself?
Actually, we have this, if you look at, going back to the comments that I made in 4910J, we can do an order, and then we can give firefighter, paramedic, a pathologist, anyone that is licensed or has the proper training to do so can do it for us. In our county, most of the professionals that have the contract with the mortuary service that we use, they are trained and certified to be able to draw the blood. And so essentially what I would be able to do is that I would be able to sign an order like I normally do for DPS. They would draw the blood for me and I can get it sent off overnight. And what's most important about that is that the body wouldn't have to leave the county in this situation, but also the blood would not leave the state, and it would be destroyed once it's complete.
Yes, and the families who suffer when there's that, the time that has to be spent to transport someone to another county and to perform the autopsy and so on and so forth, that causes just more grief. So thank you so much for
Yes,
all
ma'am.
you do.
Just a quick comment. I definitely agree with you on that. I think that's a very important part as well, especially when we're dealing with service members. There are different entities that we have to work with, and the families need closure. We need to complete a death investigation, and we just want it in a cost-effective way. But thank you for your comments and your support, madam.
Any other questions for Judge Johnson? Appreciate your testimony.
All right, thank you all for being here today. You have a great rest of your day, and thank you once again for your great work that you're doing for all fellow Texans. Good day.
Thank you, sir. Next chair calls Judge J.R. Woolley. Judge Woolley, show here that you're testifying on behalf of the Justice of the Peace and Constable Associations of Texas and yourself. Is that correct?
That is correct.
And you're testifying in support of the bill.
Yes, sir.
You may proceed.
I'm not going to go against my fellow member and say.
You did a very good job, right?
He did. So I'm not going to rehash everything he said, but I do want to do a couple things. Right now, we can order a doctor to draw blood for us. So what this bill allows, in order to get a doctor to do it, I have to send the body to a doctor. Well, for me, that's like Judge Johnson said, that's expensive to send them to an ME because that's the doctor who's going to do it. We can do it through paramedics, phlebotomists, other things for a DWI crash. So this kind of ties those two together. And I think the other part of that is it allows us to use those people to get this blood. The other part is, with some of the comments we've heard when we brought the bill were, well, do you think this will reduce autopsies? No. I mean, yes, it will, because some of them won't need to go, but I don't think it's going to make judges say, oh, yeah, he's been shot 3 times. Let's just draw his blood and not do an autopsy. No, that body's still going to go get an autopsy done. I think conversely, actually, what it's going to do is if a judge has a question, he may draw blood and then realize that something's in that blood and maybe now call the mortuary service or the funeral home and say, hey, take him to the ME's office instead. So I think it's going to give us a more accurate depiction of deaths in the state of Texas, which is one of the huge things that death certificates are about, is data collection. And if we're providing better information for those death certificates, it'll be a better outcome for Texans.
Any questions for Judge Woolley? All right, thank you for being here.
Thank you.
Appreciate your testimony. Is there anyone else here that would like to testify on, for, or against House Bill 2326? Hearing none, Chair recognizes Chairman Moody to close on the bill.
Happy to take any questions. If not, I'll close.
All right, any questions for Chairman Moody? All right. Show you closed on House Bill 2325 unless there's any objection. I'm sorry. What did I say? Okay. All right, so if there's no objection, we'll leave House Bill 2326 pending. Is there any objection? Chair hears none. Therefore, House Bill 2326 is left pending. The chair recognizes Chairman Moody on House Bill 909.
You lay out the bill. Did you lay out the bill?
Yeah. So Chair recognizes Chairman Moody to lay out House Bill 909.
Thank you, Mr. Chairman, members. House Bill 909 is a bill that allows for sentence reductions in certain cases where the prosecutor and judge both agree it's appropriate. The bill is particularly aimed at older inmates who served significant portions of their sentences. We know that the older an offender is, the less likely they are to reoffend. In fact, the parole board has long considered older age to be a positive factor in parole reviews. For that very reason, this bill gives some of those inmates a path back into society. The bill allows a prosecutor, not the inmate, to petition a court for a sentence reduction. The bill only applies to inmates who are 35 or older and have served at least 20 years, or who are 50 or older and have served at least 15 years. And some of our most serious violent and sexual offenses are excluded from the bill. The petition has to go to the court that convicted the inmate and has to lay out in concrete terms why they're not a danger to society and what mitigating factors exist to suggest that they should have their sentence reduced. The court is required to grant the request unless it finds by clear and convincing evidence that the inmate would be a danger to the community, and the bill lays out the factors the court should consider as well as the procedural framework for the process. There's also a data collection piece that requires courts to let us know annually when and how this procedure is being used. This isn't the kind of thing we'll see in many cases, but for those low-risk inmates who serve lengthy portions of their sentences and have changed their lives while serving their time, this bill offers a way to recognize and reward that change. The bottom line is this: House Bill 909 adds another tool to the toolboxes of prosecutors, one that, for once, is not another hammer. Mercy is an important part of our justice system, and where it's appropriate, it can be the exact justice that we need. I'm happy to answer any questions, and I'd like to be recognized to close after testimony.
All right, any questions for Chairman Moody? We'll move to testimony and reserve your right to close. All right, Chair calls May Lim. May Lim, Ms. Lim, I show you testifying for the people. Is that an organization?
Yes,
For
correct.
the people? And that you're testifying for the bill, is that correct?
Correct.
All right, you may proceed.
Thank you. Good afternoon, Mr. Chair and members of the committee. My name is May Lim. I'm speaking in favor of House Bill 909. I am the National Policy Manager at For the People. We are a national bipartisan nonprofit organization that supports prosecutors who are reviewing certain sentences that may no longer be in the interest of justice. Our organization is led by a former prosecutor who in 2018 wrote and helped pass the first law around prosecutor-initiated resentencing, or PIR. The law is similar to House Bill 909, which allows prosecutors to carefully review individual sentences that may no longer be in the interest of justice and where the person can be safely released. This could be a sentence that was reasonable and appropriate at the time of sentencing 15 or 20 years ago, but may no longer be just today, given changes in sentencing practices, new research we now have available, or if the person has transformed during their time in prison. If the prosecutor chooses to review a case, they must conduct a thorough and methodical review of each case in close consultation with the victim, and the judge then makes the ultimate decision, making sure that there is a system of checks and balances in place. Since 2018, 4 more states have passed PIR laws, and 7 more have proposed bills, including in Texas with the bill before you today. Like other PIR laws, House Bill 909 is discretionary, so each prosecutor can choose to opt in or to opt out and to using the law, and they can each make decisions based on the best interests of the communities that they've been elected to serve. PIR facilitates a more effective allocation of public safety resources, especially given the high healthcare costs of housing Texas's aging prison population, a population that has a relatively low risk of recidivism. Using PIR, prosecutors can help facilitate the safe release of people who have served a lengthy amount of time and have fully rehabilitated, freeing up taxpayer dollars to be dedicated toward more effective crime-reducing activities. PIR also promotes safer prisons and safer communities. Prosecutors implementing PIR have seen that the opportunity for a second look has motivated people who are incarcerated to have more positive prison behavior. They have been deterred from getting disciplinary violations and motivated to enroll in more rehabilitative programming and creating stronger reentry plans. I'll end by sharing the story of someone who was released through PIR. His name is Dean Thomas. In 2002, he was sentenced to 68 years to life for a first-degree residential burglary. He has a history of depression throughout his life, and he used drugs to treat that that mental illness, which led to the crimes that he committed. In prison, he was diagnosed finally with depression and was given the proper medicine that he needed. He started enrolling in mental health programs, and through all this programming, he really transformed his life. The people in prison with him affectionately called him the Birdman because he would mend the wings of the birds that got caught in the barbed wire of the prison fences. And so after serving 18 years, the prosecutor recommended his resentencing, and the judge ultimately resentenced him at the age of 57. He was released 3 years ago. He now lives with his mom and continues to go back to the prison every day to mend the wings of those birds and feed them. To conclude, I want to just share my gratitude with the committee for your continued leadership in advancing smart criminal justice reforms like PIR and serving as a model across the country, and appreciate you all continuing to uphold Texas's values of upholding justice, protecting public safety, and using taxpayer dollars responsibly. Thank you for your time and consideration. I'm happy to answer any questions.
Members, any questions for Ms. Lim? Chairman Darby?
Question. I noticed the criteria in which the defendant may be eligible. I don't see anything in here about victim impacts. The victims of the crimes, and are they going to have the opportunity to weigh in on this motion?
Yeah.
And the proceedings, and will be any weight given to those impact studies?
Yeah, thank you for the question, and I'll let the chair share any more information if you have as well. But I believe the bill does include a victim rights section that protects the victim's right to be notified and to be heard. And in practice, each prosecutor really carefully considers the victim's opinion when they are considering whether the person should be resentenced.
I just skimmed the bill, but I'll wait for the chairman's detailed analysis where he can direct those provisions. Thank you.
Of course.
Any other questions for Ms. Lim? All right, thank you for your testimony.
Thank you.
All right, is there anyone else here that would like to testify on, for, or against House Bill 909? Hearing none, Chair recognizes Chairman Moody to close on the bill.
Thank you very much. I appreciate that. And victims' rights are some things that we have enshrined in our law now, and so certainly wouldn't want to do anything to upend that in this process. I'll make sure that that's doubled down on. I do want, in matter just for purposes of transparency, have visited with some folks that didn't come to testify against this today. The concept is something that they don't agree with, but we're visiting with them offline. Told them that we just want to have this conversation. This would be something very new for Texas, and quite honestly would require a constitutional change, because these are powers that currently don't exist in this way in Texas. And so, you know, this is a good conversation starter, and one in which I hope we have over the years to come, because I think this is one of those tools that could be useful, but up and until we're able to get a level of comfort knowing to having the constitutional amendment come behind this, not in front of us now, but behind this is really what's going to shape the debate on this issue. So happy to take any questions.
Any other questions for Chairman Moody? All right, thank you, sir.
Thank you.
If there's no objection, House Bill 909 will be left pending. Is there any objection? The chair hears none. Therefore, House Bill 909 will be left pending. And Chair recognizes Chairman Leach. Our chair lays out House Bill 1739 and recognizes Chairman Leach to explain the bill.
There's a sub.
And Chair offers a committee substitute for House Bill 1739.
Thank you, Chairman Cook and members. Appreciate you allowing me the opportunity to lay out House Bill 1739 to you this afternoon. This substitute is in front of you, members. This is a bill relating to victims' rights. Chairman Darby, you just mentioned a really important aspect of criminal justice policy, and when we talk about criminal justice reforms, the victims of our crimes have to be at the forefront of our mind in every policy decision we make, ensuring justice for our victims, and that includes effective communications with them. Sexual assault affects 6.3 million men and women throughout their lifetimes in the state of Texas. Only a small percentage of those men and women ever report their victimization to law enforcement. It happens for a variety of reasons. but one of those can be inconsistent treatment many victims receive from the governmental authorities that are supposed to and that are charged with helping guide them through a very difficult process. Oftentimes, a survivor of sexual assault is not kept informed regarding the status of their case. They're not consulted in many instances as decisions are made. They're not kept apprised when their case may be dismissed or pled down. This leads to less engagement from victims, and it makes their path to healing and to justice much harder. The Texas Constitution states that a crime victim has the right, and Chairman Moody just referenced to this, the constitutional provision regarding a crime victim's rights to, quote, confer with a representative of the prosecutor's office and to, quote, receive information about the conviction, sentence, imprisonment, and release of the accused. And as I mentioned, members, it's our duty as legislators, as policymakers, to ensure that happens, that we're following the Constitution, not just as a mere suggestion, but as the rule. And we must ensure that those rules are followed and that the rights of the victims are satisfied and met. This bill, House Bill 1739, seeks to strengthen these protections by adding language that clearly states that a victim of sexual assault or a guardian of a victim or a close relative of a deceased victim has the right to be informed about and to confer with the prosecuting attorney about the disposition of their case. This would include sharing the victim's or their representative's views regarding any decision not to file charges, any decision relating to a potential dismissal of charges, to possibly use a pretrial intervention program, or any communications regarding any plea bargain agreements. The bill in front of you clarifies that a victim or their representative may assert and enforce any of these rights either orally or in writing. And finally, the committee substitute in front of you removes a subsection from the originally filed bill that would at present create immense implementation difficulties relating to the tracking of evidence. So, members, in closing, I believe that this is, as we talk about victims' rights, we talk about communications with victims, we talk about the state aiding prosecutors and coming alongside of victims and their families to pursue justice. I think that this bill goes a long way in achieving those important goals. I'm happy to answer any questions, and I would, Mr. Chairman, request my right to close.
Any questions for Chairman Leach? Hearing none at this time, we'll move forward testimony and reserve Chairman Leach's right to close.
Thank you.
All right, Chair recognizes Samantha McCoy. Ms. McCoy, we show that you're testifying on behalf of yourself and on behalf of the SAFE Alliance. Is that correct?
Just on behalf of myself.
Oh, I'm sorry. Can you tell me your name again?
Samantha McCoy.
Okay. All right, so we show that you're testifying on behalf of yourself in support of House Bill 1739. Is that correct?
Yes.
All right, you may proceed.
Good afternoon. My name is Samantha McCoy. I want to sincerely thank you all in advance for your time today. I am here today to speak in support of House Bill 1739 and why this bill is important to me. I was physically assaulted and raped at the age of 22 at the end of my junior year of college. As someone who had no experience with the legal system, I had no idea what to do or what to expect. The decision to report to law enforcement felt monumental, but I knew that if I did not come forward, the perpetrator would have the ability to harm others, and so I reported. During the reporting and investigative process, I felt frantic, confused, lost, and most importantly, traumatized. I fully complied with every ask that law enforcement made, despite how upsetting it was. I'm sorry. Yet I was entirely left in the dark as to what was going on. After I reported and underwent a rape examination, months went by without any communication from anyone. Law enforcement collected my phone for several weeks without explanation of really why it was necessary or how long they would even be keeping it. Sadly, I truly to this date do not know what all they did during that investigation subsequent to me reporting. Despite obtaining a civil protective order, a unanimous guilty finding by a 3-person panel Title IX investigation and hearing from my university, and the perpetrator being forced to resign from his job due to the rape. I was told by prosecution that they would not be pursuing a case against the perpetrator at that time. This information came several months later, and it crushed me. I didn't understand why, and what I went through felt as if it was all for nothing. I had no choice but to give up on justice for myself. The reporting process is not easy. Survivors are made to repeat one of the most horrific things that happened to them over and over again to strangers. Yet, after being courageous enough to report, survivors are lost in the entire process and constantly forgotten. Survivors truly deserve so much more than the ways in which they've been treated, and we owe it to each and every brave survivor that comes forward to, at the very least, keep them adequately informed at all times and ensure that justice is upheld. Thank you.
Thank you, Ms. McCoy, for taking the time to share your story. Any questions for Ms. McCoy? Thank you very much.
Thanks for your testimony.
Next, chair calls Ms. Lavinia Bertha Masters. And I think we know by now, Ms. Masters, that you're testifying on behalf of Hope Saves and yourself. Is that correct?
Yes, I am.
And in support of House Bill 1739?
1739. Thank you once again for hearing my voice. Thank you. I got to say hats off to my state of Texas for listening to survivor voices and understanding the importance. I think it was Reagan that finally made it in the 80s that said that victims have rights. And it took us a long time to get here, but we're getting there. And I'm elated to share and be a part of it. And like I said, I don't mean to offend anyone when I speak, but I think we all learn from all kind of energies when we go back and forth and we listen to survivors, the things they endure. I support House Bill 1739. I understand what Samantha went through, even with my story of not having the DNA taken, what was taken, but not hearing anything. My mother, I was 13 years old, and they never followed with my mom. And the thing about it was the police officers, this is what they asked me. They asked me 3 questions that still burn in my mind today. They said, are you sure it wasn't your boyfriend? Are you sure you didn't let him in the window? And are you sure you're not having sex and you don't want your mama to know? I was, that floored me. And over time, with no communication, no follow-up, no anything with my mother about my crime, my mother began to question me. Are you being honest with me? I didn't put a knife to my throat. I didn't slice myself. I didn't make myself bloody. I didn't know how to accept or receive that. Nobody should have to go through that. But this is what happened when we don't communicate properly, when we're not effective in making sure that the victims know their rights and what's happening with their cases and step by step and procedures or what have you. And so it's re-victimizing us. It's a systemic rape. It's our justice violating us over and over again, and we shouldn't have to go through that. And to know that we're standing here today with this law, it's a long time coming, but I think it's well worth it, and I applaud each and every one of you for listening. I don't want sympathy for anything. I want you to see the courage that survivors we have when we come forward, because we have been in the darkness for so long. We have been ignored, and I know people feel sorry for you, poor baby. No, I'm not a poor baby. I'm a survivor. I'm an overcomer. I'm standing, and I will stand for others, and we will continue to do this. And if we have to sacrifice ourselves and pour from ourselves until it's exhausting, because I'm exhausted, I'm ready for a nap today. But I will do this because I want others to have the same opportunity to be able to live and survive after something so heinous as sexual assault or any kind of traumatic experience. Thank you.
Thank you, Ms. Masters. Any questions for Ms. Masters? Right. Thank you for your testimony. Our next chair call is Ms. Juliana Gonzalez. Ms. Gonzalez, we show that you are testifying on behalf of Safe Alliance and yourself. Is that correct? And testifying in support of House Bill 1739. Is that correct?
That's correct.
All right, you may proceed. Thank you.
Thank you. Thank you for having me today. Thank you to Samantha McCoy and the Lavinia Masters. Honored to be in your presence and honored to be in their company. My name is Juliana Gonzalez. I work at the Safe Alliance. We're in support of the bill. Safe Alliance is the Rape Crisis Center in Central Texas, and we are also, and this is kind of unusual, the SANE program. So we have both the advocates and the nurses in one place. And so we are pretty deeply embedded in both the survivor experience and also in the local system response that works with law enforcement and the DA's office to respond to sexual assault crimes. It's very common for us to walk with survivors at every stage, from the first phone call, sometimes before they report to law enforcement, to jury trial several years later, although admittedly that happens much less frequently than those phone calls do. What we're asking for here is pretty simple, I think, that survivors be informed about what's happening with their case, that they have the opportunity to talk to the prosecutor about what's going to happen next, what's going to happen with their case, how it's going to be disposed. And the reasons why, I think there are several reasons for us. We have a couple different perspectives on it. One is for healing, right? Survivors are invested very deeply in these cases. They are the most important witness. Their body is the crime scene. They give up their privacy. They put their humanity on trial, and they invest an incredible amount to build this case. And so, given that they've given so much to the case, they deserve to know what's going to happen with the case. The second reason we're interested in seeing this bill pass is because of transparency and accountability. We know that these cases are very, very hard to prove. They're complicated. We know the law is sort of narrow. We know the dynamics of these relationships when they turn violent is a little bit complex. And we know that survivors don't always make the perfect victim, right? We just heard about somebody being asked as a teenager why they did or didn't take credible actions. And so we're not asking for different outcomes in these cases. We understand the constraints that prosecutors are under. We're just asking for transparency so that the community can understand and know and support bringing these cases forward alongside prosecutors. And then the third reason we want to see this bill pass, and it's pretty uncommon, but I think it's worth mentioning, that when prosecutors do meet with survivors, sometimes survivors bring forward important information. And so at times that changes the course that the prosecutor's going to take. Every once in a while we hear a situation where the prosecutor meets with the survivor and a conversation happens where the survivor says, "Oh, but did you talk to so-and-so to corroborate that? Like, they had their phone that night." Or, "Oh, but he texted me after, and I have the text," you know? And so, or, "That's not my case, you're thinking of a different one," right? And those are important things to bring forward before a disposition is made in a case. So why don't prosecutors always communicate case status to survivors? And oftentimes they do. I don't know. I think it's just that their work is very intense, and things move very fast in these cases sometimes. Maybe some of you are attorneys and you're thinking, well, I would tell the survivor, or I know people who do, I would too, and many, many do. They deliver really bad news sometimes, but they do it skillfully and compassionately because the victim deserves to know. And so that's what we're asking for, is that same standard across the board for everyone. Thank y'all. I know this has been a long day today, and you've heard some really intense stories, and we're grateful for your work.
Thank you. Any questions for Ms. Gonzalez? Thank you for your testimony. Is there anyone else here that would like to testify on behalf of House Bill 1739 on, for, or against? Hearing none, Chair recognizes Chairman Leach to close on the bill.
Thank you, Mr. Chairman. Members, in closing, I want to thank the witnesses as well for your compelling and courageous testimony. Members, when the state pursues a criminal prosecution, all prosecutions in all parts of the state are carried on, quote, "in the name and by authority of the state of Texas," close quote. The state of Texas, by way of our prosecutors, are taking up the battle for our victims and pursuing justice on their behalf. That's what prosecutions are all about. Our state statutes give our prosecutors that authority in the name and by authority of the state of Texas. But we must not lose sight of the victims in that process. There is no prosecution without a victim, and the prosecution should not proceed without the victim. And that includes constant communication. That includes protecting victims' rights. That includes partnering with the victim, not ignoring them, not stonewalling them, not stiff-arming them, but advocating on their behalf, locking arms with them, in a sense. And that this bill is meant to enshrine rights of our victims that otherwise, not in all jurisdictions, not in most jurisdictions, but in some jurisdictions are being overlooked. And this bill is a really important effort in our continued promise to lock arms with our victims and pursue justice on their behalf. Happy to take questions. If not, members, I would respectfully request your favorable consideration.
Members, any questions for Chairman Leach? All right. Hearing none, we'll move forward with withdrawing the committee substitute for House Bill 1739. And if there's no objection, we'll leave House Bill 1739 pending. Any objection? Chair hears none. Therefore, House Bill 1739 will be left pending. Chair turns it back over to Chairman Moody.
Okay, that concludes the bills that we have. Okay, we have a number of bills we're going to go through here. Chair lays out is pending business House Bill 17 by Vice Chairman Cook relating to the official misconduct and removal of district attorneys and county attorneys. This time, the chair offers up a committee substitute and recognizes Vice Chairman Cook to explain the substitute.
Thank you, Mr. Chairman. We do just have a couple of changes that I want to cover, and as we've been working through this bill, which has taken quite some time, and I do want to thank several members from the Texas District and County Attorneys Association for their input, and which was very helpful. Also, members of this committee for your time and your efforts in trying to improve House Bill 17, which I believe has landed in a good spot. So as far as the changes that have been made in the committee substitute that's before you, again, we're focusing in on the definition of official misconduct, and specifically the changes are there. It says the adoption or enforcement of a policy of categorically refusing to prosecute specific offenses under state law except a policy adopted. There's 4 exceptions in which a prosecutor would be able to rely on, and we believe that this is recognition of prosecutorial discretion on a case-by-case basis. Those 4 are: number 1, in compliance with state law or an injunction, judgment, or court order; number 2, in response to an evidentiary impediment to prosecution; number 3, to provide diversion or similar conditional dismissals of cases; and number 4, to require supervisory review or the presentation of certain specified evidence before prosecution is authorized. And again, we landed on those 4 exceptions based on the testimony that we've heard here in committee, and also just from conversations that we've had throughout with many different county attorneys and district attorneys. Also, there's in paragraph G, we made a change there before. You may remember that we laid out that it was a prima facie case if certain conduct had occurred, and instead we've changed that to a rebuttable presumption, which was a request that I received here from the Travis County District Attorney's Office, and also Chairman Moody had similar conversations with many district attorneys as well, and so that is now part of House Bill 17, and I'd be glad to answer any other questions. I did want to point out there was a question by Representative Bowers regarding some conversation we had at the layout, and that was dealing with conduct that occurred prior to a officer, district attorney, or county attorney being elected. And so I just wanted to clarify on the record that Section 87.001 of existing law says that there's no removal for prior action. An officer may not be removed under this chapter for an act that the officer committed before an election to office. So I just wanted to clarify that. And that's been in law since 1987. And I would like to make myself available for any questions if there are any.
Okay, I know there's been a lot of discussion around this. I do want to give the opportunity to, I know the substitute came back recently. Any members have questions for the vice chairman? I know that there was one conversation we had offline regarding comments forward-looking. I think you stated that the law kind of already enshrines that. That's one of the things I'd like to work on. It's not captured in this particular substitute, but it's something I'd like to tweak down the road. Just to reiterate the point, I think you are correct that the law probably lands us there in a default setting, but it's always better to be as clear as possible.
Yeah, Mr. Chairman, we did have that conversation, and I would like to confirm that I would definitely accept an amendment or be glad to offer it myself on Section 5, lines 17, 18, and 19, adding a clause that confirms what you just said.
All right, no, I appreciate that. Thank you so much. Members? Yes, Representative Bojani.
Thank you, Chairman. Thank you, Vice Chair Cook, for being willing to work with local governments on their concerns every step of the way for this bill. This body is lucky to have your leadership. To be clear, I don't like the fact that we make laws here that are not being followed. But I also know that the law and our justice system are not black and white. Being a former city council member and mayor pro tem, I'd like to give more discretion to local governments on how these laws are being implemented and enforced based on their constituents. It is for this reason I cannot support this bill at this time, but I'd like to again thank Vice Chair Cook for your work on this. We appreciate it.
Okay. Yes.
I also,
Ms. Morales.
thank you, want to thank Vice Chair Cook for the meaningful conversations that we had. I know a lot of times we know that maybe somebody on the other side of the aisle is not going to support a piece of legislation, but you really took the time to explain everything, and I appreciate you for that. Thank you.
Thank you.
All right, Representative Bowers.
Yes, thank you, Mr. Chairman, and thank you, Vice Chair Cook. I would have to agree because I feel like you really took the time to find us wherever we are in our offices or on the floor to answer the questions that we had. I can only applaud and appreciate your willingness to work together and to make sure that this is a piece of legislation that we can support. So thank you for your work, and I respectfully will not be able to support.
Thank
you. Any other questions, comments, members? No. Okay. Is there objection to the adoption of the committee substitute? The chair hears none, and the substitute is adopted. The chair moves that House Bill 17 as substituted be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody.
Aye.
Vice Chair Cook.
Aye.
Representative Bojani.
Nay.
Representative Bowers.
Nay.
Representative Darby. Representative Harrison.
Aye.
Representative Leach.
Aye.
Representative Christina Morales.
Nay.
Representative Schatzline.
Being 6 ayes and 3 nays, the motion prevails. The chair lays out as a matter of pending business House Bill 55 by Representative Julie Johnson relating to the punishment for the criminal offense of indecent assault, increasing a criminal penalty. The chair moves that House Bill 55 without amendment be reported favorably to the full House with the recommendation that do pass and be printed. The clerk will call the roll.
Chair Moody.
Aye.
Vice Chair Cook.
Aye.
Representative Bojani.
Aye.
Representative Bowers.
Aye.
Representative Darby.
Aye.
Representative Harrison.
Aye.
Representative Leach.
Aye.
Representative Christina Morales.
Aye.
Representative Schatzline.
Being 9 ayes and 0 nays, the motion prevails. At this time, the chair recalls House Bill 69 from the Subcommittee on Asset Forfeiture. The chair lays out as a matter of pending business House Bill 69 by Representative Schaefer relating to the state's burden of proof in certain asset forfeiture proceedings under the Code of Criminal Procedure. The Chair recognizes Chairman Harrison to add any commentary from the hearing on this bill in his subcommittee.
Good hearing on the bill from Representative Schaefer. It addresses two primary issues. One is an innocent owner, as well as the state's burden of proof. And I fully support us taking a vote on the bill today. Thank you, Chairman.
Chair moves that House Bill 69 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani? Aye. Representative Bowers?
Aye.
Representative Darby? Representative Harrison?
Aye.
Representative Leach?
Aye.
Representative Christina Morales?
Aye.
Representative Schatzline?
Being 9 ayes and 0 nays, the motion prevails. At this time, the chair recalls House Bill 399 by Representative Collier from the Subcommittee on Criminal Procedure. Chair lays out as a matter of pending business House Bill 399 by Representative Collier relating to automatic orders of non-disclosure of criminal history record information for certain misdemeanor defendants following successful completion of a period of deferred adjudication community supervision. The chair offers up a committee substitute. Is there objection to the adoption of the committee substitute? The chair hears none, and the substitute is adopted. The chair recognizes Chairman Bojani to offer any commentary on the bill as was heard in his subcommittee.
The hearing went well, and this is about, job applications and making a misdemeanor offenders, just make it automatic non-disclosure of them. And I recommend that we vote on this bill.
Okay. Chair moves that House Bill 399 as substituted be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani? Aye. Representative Bowers?
Aye.
Representative Darby? Representative Harrison?
Aye.
Representative Leach?
Aye.
Representative Christina Morales?
Aye.
Representative Schatzline?
There being 9 ayes and 0 nays, the motion prevails. Chair lays out as a matter of pending business House Bill 476 by Representative Jolanda Jones relating to the release of certain defendants detained in jail pending trial. At this time, the chair offers up a committee substitute. Is there objection to the adoption of the committee substitute? The chair hears none. The substitute is adopted. The chair moves that House Bill 476 as substituted be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
No.
Representative Bojani?
Aye.
Representative Bowers?
Aye.
Representative Darby? Representative Harrison?
Aye.
Representative Leach?
No.
Representative Christina Morales?
Aye.
Representative Schatzline?
Being 5 ayes and 4 nays, the motion prevails. This time, Chair recalls House Bill 946 from the Subcommittee on Criminal Procedure. Chair lays out as a matter of pending business House Bill 946 by Chairman Dutton relating to the spoliation of evidence held for use in a criminal proceeding. The chair recognizes Chairman Bojani to offer any commentary on the bill heard in his subcommittee.
Yeah, the hearing went well. There was an issue about fentanyl being excluded from this because this bill makes it reduces the punishment on lesser.
I think that's a different bill.
Oh, sorry.
That's a different bill. This one is about spoliation of evidence.
Okay. Is that 946?
946.
Okay. Yeah, I think this also it went well. There weren't any witnesses against, and I recommend voting out.
Okay. Thank you. Chair moves that House Bill 946 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani?
Aye.
Representative Bowers?
Aye.
Representative Darby? Representative Harrison?
Aye.
Representative Leach?
Aye.
Representative Christina Morales?
Aye.
Representative Schatzline?
right, being 9 ayes and 0 nays, the motion prevails. Chair lays out as a matter of pending business House Bill 1528 by Chairman Smith, relating to magistration proceedings for criminal defendants and retention of related records to services and representation provided to indigent criminal defendants and indigent juveniles, and to the governance and administration of the Texas Indigent Defense Commission. This time, the chair offers up a committee substitute. Is there objection to the adoption of the committee substitute? Chair hears none. The substitute is adopted. I have a detailed analysis from Chairman Smith regarding the substitute, and will attempt to answer any questions if anyone has any. No? Okay. Chair moves that House Bill 1528 as substituted be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody,
Aye.
Vice Chair Cook,
Aye.
Representative Bojani. Aye. Representative Bowers. Aye. Representative Darby. Aye. Representative Harrison.
Aye.
Representative Leach.
Aye.
Representative Christina Morales. Aye. Representative Schatzline.
Being 9 ayes and 0 nays, the motion prevails. The chair lays out as a matter of pending business House Bill 1709 by Chairman Canales, relating to a special bill of review to reform a final judgment of forfeiture of a bail bond. Chair moves that House Bill 1709 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody,
Aye.
Vice Chair Cook,
Aye.
Representative Bojani. Aye. Representative Bowers.
Aye.
Representative Darby. Representative Harrison.
Aye.
Representative Leach.
Aye.
Representative Christina Morales. Aye. Representative Schatzline.
Being 9 ayes and 0 nays, the motion prevails. Chair lays out as a matter of pending business House Bill 1769 by Chairman Meyer, relating to the statute of limitations for certain offenses committed against children. The chair moves that House Bill 1769 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody,
Aye.
Vice Chair Cook,
Aye.
Representative Bojani.
Aye.
Representative Bowers.
Aye.
Representative Darby. Representative Leach, Harrison, sorry. Representative Leach.
Aye.
Representative Christina Morales. Aye. Representative Schatzline.
There being 9 ayes and 0 nays, the motion prevails. The chair lays out as a matter of pending business House Bill 1784 by Chairman Landgraf, relating to certain requirements of protective orders and conditions of release on bond and to the criminal penalties for violating those requirements and conditions. The chair moves that House Bill 1784 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody,
Aye.
Vice Chair Cook,
Aye.
Representative Bojani. Aye. Representative Bowers.
Aye.
Representative Darby. Representative Harrison.
Aye.
Representative Leach.
Aye.
Representative Christina Morales.
Aye.
Representative Schatzline.
There being 9 ayes and 0 nays, the motion prevails. Chair lays out as a matter of pending business House Bill 2055 by Representative Venton Jones, relating to the repeal of the criminal offense of homosexual conduct. This time, the chair offers up a committee substitute to House Bill 2055. Let me explain very quickly the substitute language based on, I think, a lot of the questions that we had, some of the questions that Chairman Leach asked. This substitute essentially removes any of the redacted language from the instructional elements, the educational pieces that we heard testimony against. So all of those pieces are left in the Health and Safety Code in sections 2, I'm sorry, excuse me, I apologize, in section 3 of the bill. And so this now becomes a strict criminal law repealer. There is no other change in law other than the penal code provision that has been held unconstitutional is stricken from the code, and then the cross references to it are stricken as well. The cross reference reads, and that homosexual conduct is a criminal offense under section 21.06 of the penal code. So that's the only piece that's stricken in the health and safety code to mirror the fact that we're striking it out of the penal code. Are there any questions on the substitute? Is there objection to the adoption of the committee substitute? The chair hears none and the substitute is adopted. The chair moves that House Bill 2055 as substituted be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody,
Aye.
Vice Chair Cook,
Aye.
Representative Bojani.
Aye.
Representative Bowers?
Aye.
Representative Darby? Representative Harrison?
Aye.
Representative Leach?
Aye.
Representative Christine Morales?
Yes.
Representative Schatzline?
There being 9 ayes and 0 nays, the motion prevails. Chair lays out as pending business House Bill 2306 by Representative Hefner relating to the prosecution of the criminal offense of voyeurism. The chair moves that House Bill 2306 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani?
Aye.
Representative Bowers?
Aye.
Representative Darby? Representative Harrison?
Aye.
Representative Leach?
Aye.
Representative Christine Morales?
Aye.
Representative Schatzline?
There being 9 ayes and 0 nays, the motion prevails. The chair lays out as a matter of pending business House Bill 3659 by Representative Hefner relating to civil asset forfeiture proceedings, to the seizure and forfeiture of certain property, and to the reporting and disposition of proceeds and property from civil asset forfeiture. This time, the chair offers up a committee substitute. Is there objection to the adoption of the committee substitute? The chair hears none, and the substitute is adopted. The chair moves that House Bill 3659 as substituted be reported favorably to the full House with the recommendation that it do pass and be printed. Clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani?
Aye.
Representative Bowers? Representative Darby? Representative Harrison?
Aye.
Representative Leach?
Aye.
Representative Christine Morales?
Aye.
Representative Schatzline?
There being 9 ayes and 0 nays, the motion prevails. This time, the chair lays out as a matter of pending business, House Bill 4061 by Representative Schatzline relating to prohibiting a registered sex offender from going within a certain distance of the residence of a victim of any offense committed by the offender for which the offender is subject to registration. This time, the chair offers up a committee substitute. Mr. Representative Schatzline, do you want to explain the substitute?
Sure. So essentially, the only thing this substitute does is make sure that the actual victim of the crime is not prohibited from living where they want to live. In other words, if they were to move into an area where their offender was currently living next door, that offender would not be forced to move at that point, and the actual victim would not be forced to not move into that area as well, if that makes sense.
Okay. Members, do you have any questions on the substitute since we have the author here? No? Is there an objection to the adoption of the committee substitute? The chair hears none. The substitute is adopted. The chair moves that House Bill 4061 as substituted be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani?
Aye.
Representative Bowers?
Aye.
Representative Darby? Representative Harrison?
Aye.
Representative Leach?
Aye.
Representative Christine Morales?
Aye.
Representative Schatzline?
There being 9 ayes and 0 nays, the motion prevails. The last bill to vote today, the chair lays out as a matter of pending business, House Bill 1993 by Chairman Cody Harris relating to the authority of a peace officer commissioned by the comptroller to apply for an order authorizing the installation and use of a mobile tracking device. We heard this earlier today. Mr. Harris had asked us to consider sending it to his committee. Okay, all right. No, I just want to make sure I do that the right way. The chair moves that House Bill 1993 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed and be sent to the Committee on Local and Consent Calendars. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani? Representative Bowers? Representative Darby? Representative Harrison? Representative Leach?
Aye.
Representative Christine Morales?
Aye.
Representative Schatzline?
Being 9 ayes and 0 nays, the motion prevails. All right. Thank you, members. You may have other things to do, but you don't have anything left to do here. I hope everybody gets some rest in anticipation of the budget. Do you have the time on here? Is there any other further business to be to address for the committee today? If not, the chair moves to adjourn. Is there objection? Hearing none, the committee stands adjourned at 3:56 p.m., subject to the call of the chair. Thank you, members.